This application hearing is in the matter of case number CFI 053-2022 and is being held by way of video conference before His Excellency Deputy Chief Justice Adil Madhani. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al Suwaidi and Company LLC. Lead counsel is Mr. Mohammed Suwaidi. The defendant is represented by Consulas Law. Lead counsel is Mr. Raza Madhani. Would the judge and the parties' counsel please confirm that the situation is as I have stated?
This is correct.
Thank you, Shahla. Good morning again. Well, we are here today to hear an immediate judgment application raised by the defendant, Mr. Mahdi Amjad. Immediate judgment application based on 4 grounds plus a security for cost application, where the defendant is the applicant in this application, when the claimant is the respondent. Mr. Reza Madhani and Mr. Suwaidi, I'm just telling you, I have read your case, your submission, the witness statement, and the document surrounding. Just to this is to comfort you so that you don't have to take me through everything unless the very necessary one. But that doesn't mean I'm confiscating any of your times. I mean, the time allocated to you, because it's been paid for. So that's why. I mean, with my pre-reading, with your preparation, we should not take more than the designated time for us. Thank you, Mr. Madhani. Unless there is any housekeeping matters, you may go on.
Your Excellency, there are no housekeeping matters, and I'm grateful that Your Excellency isn't confiscating anything, because the last time I had something confiscated was, I think, when I was at school.
Yeah, we're here to ensure that everyone gets his right and present his case fairly, Mr. Madhani. I'm sure you have dealt with this court many times before.
I have, and I'm grateful. As Your Excellency rightly pointed out, the primary application before the court today is for immediate judgment, dismissing the claim on the grounds that the claim has no real prospect of success, and there is no other compelling reason why the case should be disposed of at trial, or alternatively, striking out the amended particulars of claim on the grounds that it discloses no reasonable grounds for bringing the claim. Very much in the alternative, if, for example, the court were minded only to strike out part of the amended particulars of claim, the defendant applies for security for costs. Your Excellency, I begin by saying this. We have all seen claims that have no real prospect of success before. Such claims often have a pattern, not just as to their substance, or perhaps more accurately, lack of substance, but also the manner in which they are litigated. The claim which is before Your Excellency, however, is perhaps unique in the degree to which it is misconceived. So, for example, the claim has been brought under an agreement by a claimant who was not a party to that agreement against a defendant who also was not a party to that agreement. The real claimant, if I can use that word in inverted commas, in this case is a Mr. Khaldun Tabari. Mr. Tabari was named as the culprit in an alleged over 1 billion dirham insider fraud of Drake and Skull, a company of which he was.
Excuse me, Your Honor. I don't think this issue is a subject of our case here. Please, I don't think I need even this. This has been stated in the memorandum that was submitted by my learned colleague. I think it's irrelevant to the case. So please, I object to continue in this discussion.
It's already been said, Mr. Suwaidi. You know, and this is court. It's a public court. It's everything can be said, Mr. Suwaidi. Nothing to hide. I mean, unless he's saying something, I mean, untrue, so you could have your reservation fairly. But I mean, you just said it, and you may go on. I mean, Mr. Madhani. Thank you, Mr. Suwaidi.
Thank you, Your Honour. In relation to Mr. Suwaidi's point that it's not relevant, in fact it is, and I shall demonstrate exactly why it is relevant. I believe that it's already been demonstrated in the evidence, but these are matters which I shall address in more detail. Mr. Tabari's assets in the UAE were frozen by the public prosecutor in 2018, and an Interpol red notice was issued for his extradition to the UAE. The defendant submits that the claim has no real prospect of success. It appears that Mr. Tabari perhaps agrees with that, as he has not had sufficient confidence in his claim to bring it in his own name. Instead, he has chosen to bring the claim in the name of an insolvent company, Vision Investment and Holdings Limited, which I'll refer to as VIH, just for ease of reference, to shield himself from an adverse costs order. Bringing the claim in the name of VIH also serves another purpose. If the claim was successful, it avoids the proceeds of any judgment falling within any continuing freezing order made by the public prosecutor, and avoids claims by Mr. Tabari's creditors from attaching to the proceeds of any judgment. I've set out the background, if you like, the factual matrix to the case in paragraph 3 of my skeleton argument. I'm happy to take Your Honour through that if it would be helpful. If it's not helpful, I'm happy to move on.
I've read it twice. I'm aware of it. Yes, you may move on.
I'm very grateful. In that case, I shall move on to the, before I move on to the substantive grounds for the application for immediate judgment and strikeout, I would very shortly like to address the issue of applicable law. It's now been conceded by counsel for the claimant that the applicable law is UAE law, i.e. UAE law as applied in the Emirate of Dubai and not DIFC law. The claimant's original decision to wrongly argue that DIFC law was applicable appears to have been driven by a recognition that on the application of UAE law, its claim would have no real prospect of success. Why do I say that? I say that because that is, in my submission, the obvious inference from the fact that it first raised its incorrect argument that DIFC law was applicable in its reply, after seeing the detailed UAE law defences pleaded by the claimant in its defence. But in fairness to the claimant, they have now conceded the point, given that it's of course hopeless for them to argue that DIFC law is the applicable law.
But Mr. Madhani, my understanding, the parties have finally agreed.
Yes.
The UAE civil and commercial law apply to this. Is that right?
That's correct. Yes.
This is the standing situation today.
Yes. So it's UAE.
Okay, then we should not invest a lot of time talking about the disagreement that happened before the agreement.
Indeed. Your Honour will be familiar with the provisions that deal with immediate judgment and strikeout. I've set them out at paragraph 6 of my skeleton argument and paragraph 7 of my skeleton argument.
Yes, CRDC 416 and
yes,
24.1. Yes,
indeed, and Your Excellency will be familiar with those provisions. The relevant principles to be applied on an application for immediate judgment are of course well settled, and they were recently restated by the DIFC Court of Appeal in Emirates NBD against Advanced Environmental Services. Your Excellency has a copy of the judgment. I don't intend to go through the principles because Your Excellency will be familiar with them. But there are two principles in particular that are just worth drawing out. And those are that the court must consider whether the claimant has a realistic as opposed to fanciful prospect of success. And secondly, a realistic claim is one which carries some degree of conviction. This means that a claim is more than merely arguable. So it's not sufficient for a claim to just be arguable to resist a application for immediate judgment. It must be more than merely arguable. In my submission, there are 4 grounds upon which immediate judgment ought to be given against the claimant. Those grounds stand as independent grounds. So if Your Excellency is with me on any one of those grounds, then I would invite Your Excellency to dismiss the claim. Going through those grounds in turn, if I may first address you on the first ground, ground number 1, the claimant is not a party to the ALSA. I've used the abbreviation ALSA, Amended Loan Services Agreement,
I'm
as
good
a
with that.
fairly the reason I've used it is I've tried to use a fairly neutral phrase that both parties may be comfortable with.
And I know Mr. Suwaidi emphasized also or insist that you need to rely more on the previous document, which is not the amended.
That is
I understand the position. Yeah,
that is perhaps his submission.
exactly.
Let's start, Your Excellency, with some common ground between the parties. What is in fact agreed? What is in fact agreed is that VIH was not a party to the ALSA. And it is also agreed that VIH did not loan any monies to Town Square. Accordingly, there are 3 reasons why the claim has no real prospect of success on this ground. Firstly, as a non-party, VIH's claim falls foul of the rules on privity enshrined in UAE law, and no alternative legal basis has been pleaded by the claimant as to why it purports to have standing to make its claim. The second is that VIH has never provided a legitimate or convincing reason as to why Mr. Tubbery has failed to bring the claim in his own name. And thirdly, even if the court accepts an argument by VIH that it has a joint right to bring the claim because such a right was conferred upon it by the ALSA, its claim would still be bound to fail for non-compliance with RDC 20.10. Now, going through each of those arguments in a little bit more detail. Firstly, the privity argument. The doctrine of privity is enshrined in UAE law. So I've set out in my skeleton argument just 2 illustrations of that. The first is Article 129 of the Civil Code, which I've set out at paragraph 13A of the skeleton argument. The essentials for making, yes, the essentials for making a contract are the 2 parties of the contract should mutually agree, should mutually consent to the basic elements. And Article 1411 of the Civil Code, which states that a contract will not be concluded upon the agreement of the 2 parties to the basic elements of the obligation and the other lawful conditions that the parties regard as basic. It's implicit within both of those provisions that the contract creates rights and obligations as between the contracting parties, not vis-a-vis third parties. Neither provision, for example, says that a contract can give a right to a third party. So VIH hasn't pleaded an alternative legal basis upon which it says that it has locus standi. Instead, what we've seen from VIH is a bare assertion made in its witness statement in opposition to the application. And this is Mr. Suwaidi's first witness statement, in which it's stated on behalf of the claimant that it goes without saying that a contract cannot bind a third party to an obligation, but a right to a third party can be granted. Well, the first part of that proposition is correct. It does go without saying that a contract cannot bind a third party to an obligation. But the second part is, in my submission, not. If Mr. Suwaidi or the claimant wishes to make that submission, it's a submission which ought to be supported by law. As matters stand, it is not. Hence the argument that the claim discloses no reasonable grounds for bringing the action. However, even if one were to give the claimant the benefit of the doubt, and I do this for the purposes of argument, and even if we were to accept that that proposition is legally correct, it still does not assist VIH, as neither the LSA, that's to say the Loan Services Agreement, or the amendment vested any right in VIH. There's a difference here between a right and a benefit, and one must not conflate the two, even though I would say there isn't a benefit, but there certainly isn't a right. Whilst Mr. Tabari and Town Square agreed in the LSA and subsequently the amendment that monies loaned by Mr. Tabari be repaid to him in cheques drawn in the name of VIH, in my submission, that was nothing more than a payment mechanism. What it didn't do was it didn't give VIH a right which it could enforce, certainly not a right which it could enforce against Mr. Amjad. And the basis for this argument is threefold. Firstly, at its most basic, the ALSA did not say in terms that it gave VIH the right to enforce any obligations under it. Any right of enforcement, therefore, vested in the party to the agreement, that's to say, Mr. Tabari.
Mr. Madhani, you're saying whatever the claimant is arguing here, and even the mention of their name in the check or as a payee in that checks, that does not qualify to the principle of a transfer of right. Right is not never been transferred by any document to the Vision investment. That's what you're saying.
Yes, indeed, Your Honor. So the right has never been transferred. So if for example, just for the sake of argument, if for example the loan services agreement or the amended loan services agreements had been signed by Mr. Amjad in his personal capacity, and there was a specific clause in the contract that said something along the lines of, although VIH is not a party to this agreement, it will have the right to bring any claim under this agreement. So, and that's not a theoretical submission. So, for example, there are similar, there are similar rights under the and I know English law isn't relevant here, but it's just for the purposes of illustrating the point. There are similar rights that one can obtain under the English Third Party Contracts Act, where one can put into a contract a specific provision that says that a non-party can sue under it. But that provision is not present in this contract. So that's, if you like, the starting point of the argument. But then the argument becomes stronger as we move along, and it becomes stronger as we move along, because the second limb of the argument is this: VIH did not loan any monies to Town Square. That's accepted. That's accepted by the. It didn't have any ostensible role in the transaction between Mr. Tabari and Town Square. And there has never been an explanation from VIH as to why Mr. Tabari was funneling money to VIH, this DIFC entity, for no apparent consideration, when it didn't provide any of the loan monies. It had no role in this transaction. And I'll come on to that in a little bit more detail a little later.
But tell me, I mean, what's the purpose? I mean, or let's say, what's the legal consequences for nominating a Vision as a, let's say, a beneficiary or receiver to this
Yes.
money?
So,
I do want to take it to the trust, like if it's a trust company, I mean a trust contract or any mean of a trust, they
Yes.
might have a standing. I mean, we're not common law. This is not trust, not common law trust. They might be a beneficiaries that, which is might give them sort of right to claim the trust in someone else's hands. But this is, let's go. This is a UAE civil code transaction, maybe commercial transaction.
Yes.
But Mrs. Suwaidi saying, well, the claimant names are mentioned, they are supposed to be the receivers of the money loaned to the defendant.
So
And yeah, so their name as a receiver in the contract, I mean, not the amended one, but the loan settlement agreement, I mean, the LSA. What inference we can get from that?
So Your Honour, the simple fact is this, and Your Excellency and I are in a little bit of difficulty because we are both in a position where we are trying to guess what the basis of the claimant's legal argument is, that these third-party rights exist. And the reason that we're trying to guess is because they haven't been set out, they haven't been pleaded. And giving both Your Excellency and I the benefit here, it's not for either of us to give the claimant its legal basis for pursuing the claim. If the claimant says it's got a legal basis under UAE law for pursuing the claim, it has to plead it. It has to set that basis out. It hasn't. It would be open to Your Honour to simply leave it there and say the legal basis hasn't been set out. Therefore, it discloses no reasonable cause of action. And it would be open to me on this point to finish my submissions there and say, well, that's it. I don't need to go further and address a potential ground on which the claimant could have brought this or might be thinking to bring this or what might be in the claimant's mind. But the reason I've gone that step further is to show that even if one accepts that legal proposition, which has been put forward at a late stage by the claimant as correct, it's not correct because there's no basis for it that's been pleaded. But even if we were to accept that it's correct, it doesn't go anywhere. It doesn't take.
You said they have not pleaded certain cause of action, so they cannot hold to it now.
Indeed, and there's actually a very interesting sense check that we can do in relation to this argument that's put forward by the claimant. Again, even if we were to take their argument at its highest and we were to pretend for a moment that there was some merit in the legal argument, which is unparticularized and hasn't been set out. But if we were to sort of take it at its highest, if we did a sense check and we asked ourselves the question, let's test whether the right vested in Mr. Tubbery or in VIH, we will find that clearly the right didn't vest in VIH. And when I say the right didn't vest in VIH, what I mean is that if there was a claim to be brought under this contract, the person to bring it would be Mr. Tubbery. So if Mr. Tubbery had brought this claim and said, I'm bringing a claim under this contract because I have the right to claim that these monies have not been paid, and if Mr. Tubbery brought that claim against Town Square, then he would have standing to bring that claim. It's not that nobody has the standing to bring that claim. It's not that the claim has disappeared. Mr. Tubbery is the counterparty to that agreement, and he has the right to bring a claim under the agreement. Whether that's a good claim or not, that's a different question. But as to who's got locus standi to bring the claim, that would be Mr. Tubbery. Now, back to the thought experiment. It would have been open to Mr. Tubbery as the counterparty to the ALSA at any time to ask Town Square to pay the monies to his personal account or through some other payment mechanism. Now, if that had happened, what would have the result be? If the day after the LSA had been entered into, or the day after the amendment had been entered into, Mr. Tubbery rang up Town Square and said, well, you know what, I don't want you to pay these checks to VIH. I want you to pay them to my personal account. Well, what would have happened? What would have happened is that VIH wouldn't then have had a claim against Town Square. VIH wouldn't have had a claim against Mr. Tubbery because there was no consideration provided by VIH. And in fact,
but Mr. Suwaidi, I think this is a very important point. I mean, if you just take note of it, you reply in your turn. Yes, Mr. Madhani, go on.
So it's accordingly, Your Excellency, it's clear that the right to enforce the payment under the ALSA, whether that payment should be made to VIH or to somebody else or to Mr. Tubbery personally, that right has always subsisted in one person. And the one person that it subsisted in is Mr. Tubbery. And it's in fact curious because some of the claims under the LSA and the amendment are expressed as payments that payments to be made to VIH. Others are not. So, for example, there's one payment that's expressed to be made to a completely different company, a company called KRT4 Limited. KRT4 Limited isn't a party to this claim. So one gets a picture as to what Mr. Tubbery was doing here. He kept the rights in the agreement for himself, but he was saying, well, you pay this person, you pay that person, and if I want to change my mind and require you to pay to somebody else, I can do that too. And in fact, if I take Your Excellency to page 75 of the bundle, this becomes very clear.
You said 75?
Yes.
Bear with me.
Sorry, what number, please?
75.
The loan agreement, yes. The loan settlement agreement.
The loan settlement agreement.
Right.
In fact, the phrase loan settlement agreement, although that's what the agreement is called, it's a slight misnomer. But I'll come to that point a little bit later. Here, the crucial point that I make is if Your Excellency goes about halfway down the page to the
Right.
3 bullet points, the second bullet point says the second party, and the second party is Mr. Tubbery. The second party shall also be entitled to deposit such checks to the bank, comma. So that's one thing Mr. Tubbery can do. He can take the checks and he can endorse them as he wishes. Or he can endorse them to a third party, so they can be paid to a third party. He can require payment to be made to another party, or deducted at bank. So there are a number of different things that Mr. Tubbery can do. So not only is there an implicit right that Mr. Tubbery can at any point say, I want these payments to be made in a different way, but he's actually set out and reserved an express right to himself within the LSA itself. The second argument
So you're saying, despite the fact that this check is for VIH name, so
Yes,
Mr. got a lot of powers here to deal with this check, or to do
yes,
whatever he wants with them,
yes.
to endorse them to the third party.
I mean, they're clearly that this second paragraph clearly sets out three different things that he can do with this check, with these checks. He can, and this is as I say, this is in addition to the general right he has to give an instruction that I want these payments to be made. Oh, today I want these payments to be made to KRT4 Limited. Tomorrow I want these payments to be made to a company in the BVI or the Cayman Islands. But in addition to this second paragraph clearly says the second party shall also be entitled to deposit such checks to the bank. So that's option number one. Endorse the same to a third party. So that's option number two. The checks can be endorsed in the name of another party or deducted at bank. That's a third option. There are three different options here. So when there these various options there, it's a nonsense to say that the right is a right vested in VIH. That the right has to be a right vested in the person who's in control. And the person who's in control, we know is Mr. Tubbery. The person who is a signatory to the agreement is Mr. Tubbery. The person who loaned the monies is Mr. Tubbery. But Mr. Tubbery, for reasons known only to himself, has put these different mechanisms into this agreement. And it may be that the background as to what was happening at the time that Mr. Suwaidi doesn't want me to talk about provides an explanation for that, or at the very least, it provides a context. So I shall move on to the second limb of this argument, unless Your Excellency has any questions in relation to the first limb.
Yeah, if you just give me a minute, I'm reading this again.
Yes.
What do you say this? It said that's the total amount of the payment indicated above is 32 million, blah, blah, as a remaining balance of the loan amount and its interest due in favor of Vision Investment and Holding Company as the request from the second party.
Yes.
This is before where the statement when you took me to the second party shall also be entitled to
Yes.
deposit such check. I mean, what inference you draw from that?
So there are a number of inferences to draw from that, Your Honor. The first inference is that these were never monies that were loaned by VIH, but the checks to be provided were due to be made out to VIH because that is the payment mechanism. So that wording there simply is a reflection of the payment mechanism. What that wording doesn't say, and this is really the crucial point, the wording there doesn't say that Vision Investment and Holdings Limited shall have the right to enforce any obligations under this agreement. That's the crucial wording that isn't there. And the absence of that wording means that they don't have standing, they don't have locus. And so it means that the person that does have standing and does have locus is Mr. Tubbery. And that is reflected in the fact that he's the party to the agreement, but it's also reflected then in that third subparagraph, which is the second party shall also be entitled to deposit such checks to the bank endorsed, etc., etc. So again, I come back to the point that it's not that the right somehow disappears. So there's no prejudice to Mr. Tubbery here. There's no prejudice to him at all. He could have brought the claim in his own name. He could have done, but he hasn't. And that really raises a significant question as to why he hasn't. And that's what brings me on to my second point, which is that if he believed that he had a genuine claim against Mr. Amjad, he could have brought it. There's been an astonishing failure on the part of VIH to explain why Mr. Tabri has not. And in a normal case, when a question like this just is not answered, just is not answered, and just is not answered, that raises...
But I'm supposed to stay in page 75, where Mr. Suwaidi referred to him as the third paragraph, the third bullet point in the same page, which nominate him as, and I'm not saying nominate him, but it said, in the event of any indicated checks is written and paid, Mr. Mahdi Amjad shall be the guarantor and be personally responsible for the payment of the return checks. So we're gonna, I mean, start from here, yeah?
Yes. So,
Okay.
yes. So the third paragraph is the alleged guarantee that Mr. Suwaidi relies upon, and I shall address the alleged guarantee, because that's my second submission. I'm still on my first.
No, yeah, I understand, sir, but sir, I said where the claimant comes from. I said that's what I see.
Oh yeah.
So I said I would pause here and I would listen to you,
Yes.
bearing in mind Mr. Suwaidi's argument. Yes.
Yes, but Your Honor makes a very valid point, in that even if one filters down to that third subparagraph, there are various reasons which I shall come on to as to why we say Mr. Amjad has not given a guarantee in this case. But again, if we were to suspend our disbelief and we were to say that this paragraph did constitute a valid guarantee, again, one looks at that paragraph and there is nothing within that paragraph which says that VIH has the right to bring a claim against Mr. Mahdi Amjad in the event of failure to provide the checks. So again, there's no specific right vested in VIH as against Town Square.
I see your bench. You
But
said
also as
you said
against
you said
Mr.
you're saying the claimant, even if they succeeded to say they have a right to
Yes.
sue based on this agreement, then they shouldn't sue against Ms. Amjad, but maybe against Times Square. That's what you're saying.
Yes, indeed, and that's my second.
That's what you're saying, yeah.
Yes, and that's my second.
That's the highest where VIH can go. You're saying.
So what I'm saying is that each of these grounds that I've set out, each of the four grounds, stands independently as to why the claim should be dismissed. The first ground, which is the ground I'm addressing now, is that VIH itself wasn't a party to the agreement. The second ground, which I shall come on to in a little bit later, is that even if VIH did have standing under the agreement, Mr. Amjad has never been a party to the agreement. There are no rights that have been given against Mr. Amjad under the agreement at all. He wasn't a signatory. He's not a party. But in relation to the first point, moving on to the second limb of it, there has been no explanation as to why Mr. Tabri hasn't brought the claim in his own name. And the reason this is particularly alarming is because this is an individual against whom an Interpol red notice was previously issued. The UAE public prosecutor made a freezing order against his assets, and he was accused of committing a fraud, one of the largest in the history of the UAE, for over 1 billion dirhams. And what that means, Mr. Suwaidi would perhaps have the court believe that I'm making this submission simply to colour the court's mind as to what sort of character Mr. Tabari is. I'm not. This is a matter that is firmly relevant to the application and to the proceedings. And the reason it's firmly relevant is because if there was a judgment that was given in favour of VIH rather than Mr. Tabari, remember the monies were never loaned by VIH. The monies were loaned by Mr. Tabari. The effect of that would be twofold. Firstly, it would circumvent any freezing order made by the public prosecutor that may remain outstanding against him, because those monies would fall into VIH, and the legal ownership of VIH does not rest with Mr. Tabari. The legal ownership of VIH rests with his family members. So it's the old, and there were transfers of ownership. And those transfers of ownership are set out in the evidence that we have submitted. So that would be the first effect. The other effect would be that it would have the impact of avoiding claims by Mr. Tabari's creditors. So suddenly, if there was a judgment in favour of VIH rather than a judgment in favour of Mr. Tabari, well, Mr. Tabari's creditors couldn't go against VIH because Mr. Tabari is not the owner of VIH, or at least he's not the legal owner. Whether he's the beneficial owner of VIH or not is an important question, and it's a question which has not been answered by the claimant, and it's been asked a number of times. And that's set out in the correspondence. I'm happy to take you to that correspondence later, as that will form part of my submissions. But that includes the fact that Your Excellency will be aware that under DIFC law, it's a legal requirement to keep what's known as a beneficial, a register of beneficial owners of the company. So there's actually a register of beneficial owners. That document has been requested in correspondence. It has not been provided. It has also been requested in disclosure, and it has not been provided. So these are crucial issues that go to the heart of the application. And again, just for the sake of completeness, it's worth stating that there has never been any dispute between the parties that an Interpol red notice was issued against Mr. Tabari. That's never been disputed. It's never been disputed that Mr. Tabari was accused of a fraud in relation to Drake and Skull, worth over £1 billion dirhams. That's never been disputed. The only thing that's been disputed by the claimant is the claimant, naturally, as one would expect, says, well, Mr. Tabari wasn't guilty of these matters. But the fact that this all happened is something that has never been disputed. The fact that an extradition request was made, again, it's not something that has been disputed. We've asked, and again, I can take your honour to the correspondence later. The question has been asked on a number of occasions as to what outstanding civil and criminal proceedings are there against Mr. Tabari. That hasn't been answered. Requests for documents in relation to those proceedings have been made, requests in correspondence and also by way of formal disclosure requests pursuant to the case management order of Judge Nasser. Those have not been answered. The point hasn't been addressed by the claimant in the evidence in reply because they say, well, this is just not relevant.
Yeah, but why you want to go, I mean, to take the discovery to that level? I mean, you have a case, you're dealing, you got a defense against certain party. Why you need to know? I mean, it's not a new right. I'm not saying it's not a new right at all.
Yes.
But this is supposed to be public domain information, you know what I mean? But sometimes the authority are not, I mean, up to that level, but sometimes they are. But I'm saying, well, let's suppose whatever is Mr. Tabari is the worst or the best man in the world. Okay, we got a contract here. You can as you are already putting your defense saying, the current person is not the person who got no standing. I mean, bringing this case. And if he have a standing, it should be against Times Square, not against Mr. Mahdi at all. And now where Mr. Tabari is now, or where did he disappear or flood or where? I don't know where that would take us. I mean, why you need that information?
Well, Your Honor asks a valid question, and that's a question.
No, I understand you saying if it's in that capacity. I mean, a person like Mr. Tabari, he's in a high debt. Wherever he got a right to by would be subject of attachment of, let's say, the public prosecution. Well, understand, you might say this is a shortcut or I don't know, it's a different means of, let's say, a dissipation, if you would like to say it. Okay, I mean, I would go with you hypothetically. I mean, let's take it hypothetically. That's the case. I mean, you didn't need to say it. You can just tell me this is, let's say, academically, this is the point, and where are we going? I mean, without the need to get any documentation where he is now or what he's doing. I mean, I'll believe if you say that, I'll believe you, and I will go to that level.
Yes.
I said we didn't need to prove it unless we really there is a very high need that we need to prove it. But if we said, Judge Ali, hypothetically, academically, this guy is wanted.
Yes.
He can't have an asset here because he's in debt for over $1 billion. And if it's termed to be right that he got a right under this agreement, so that right would be for the creditors, not for him, by any means. So that he will pass by and whatever. So I'll go with you this case. You didn't have to prove it. But
Yes.
if you can show me there is it's hypothetically valid, then we'll go with you.
I'm grateful, and Your Honor is absolutely right in that we on this claim we don't have to prove that wrongdoing was actually happened or didn't happen, and that's not simply that's not what we're seeking to do. What we're seeking to do is to provide the court with the information it needs to see the context, and if I can then just move on.
Yes, please.
To an additional point, which is that
I would like to ask you one thing, Mr. Madhani. I mean, you're discussing this case and you're referring to the loan settlement agreement and amended loan settlement agreement, which I think have been drafted in Arabic, the first version, yes, and then translated into English. Do you have any problem with the translation? You're fine? Like, have you double checked it's like the Arabic match the English one? You're okay with that?
So the translations that we've submitted with our
because I got both Arabic and English,
yes,
and I didn't know. My suspicion the Arabic one is the original one. Is that right, Mrs. Swedi?
Yes.
Yes. So if there is any doubt with the translation, then the Arabic should supersede. But you're not saying there is any wrong with the translation so far, yeah?
No. So
or you haven't discovered one yet.
So I'm afraid, Your Honor, my Arabic is very poor because I was a poor student when I was a child.
Shouldn't be the case. You're 20 years, well, more than 20 years in Dubai, I guess now, Mr. Madhani.
So I'm seeking to improve it, but it's a slow process. However, so far as the translations are concerned, the English translations that we've submitted, together with our application, so these are exhibited at MRM1 of my witness statement, and that's the translation I took you to. We are content with those translations.
Thank you.
So if I can just move on then, Your Excellency, to the final limb of this argument, and in some ways this is perhaps one of the most crucial limbs of this argument, because this limb of this argument works even if the other limbs fail. So even if, again, we took the claimant's case at its highest and we said, yes, we accept that there is some sort of right, joint right which has been conferred on VIH under the amended loan services agreement, even if we don't accept it, but for the sake of argument, if we were to say we did accept it, nonetheless, the claim would fail and the claim would be bound to fail. And the reason the claim would be bound to fail is because of RDC 20.10. And this isn't a technical, it's very important to set out, but this isn't a technical breach of the rules. I'm not relying on a technical breach of the rules. It's a substantive matter, it's a substantive issue. So RDC 20.10 states, and I've extracted it at paragraph 24 of my skeleton argument, where a claimant claims a remedy to which some other person is jointly entitled with him, all persons jointly entitled to the remedy must be parties, unless the court orders otherwise. So that's the must is the mandatory language. Other places in the rules, we sometimes see language that says should or may, which is directory rather than mandatory, but must is very clearly mandatory. And what is the purpose of this rule? What is the purpose of RDC 20.10? It reflects a similar provision in the English CPR. And the purpose of it is that all of the relevant parties who have an interest in the subject matter of the claim should be before the court and should be bound by any judgment that's made. And in relation to RDC 20.10, the simple fact is, firstly, Mr. Tabari is not a party to the proceedings. Point number one. Point number two, there's never been a request made by the claimant that an alternative order should be made under RDC 20.10. That there's no such request was made in the claim form, in the particulars of claim, in the amended particulars of claim, in the reply, in the amended reply. We've had a lot of pleadings in this case. That request has never been made. It was never made in response to this application either. And in saying that, I don't make a criticism of Mr. Suwaidi, because even if such an application had been made, such an application would be bound to fail. Because to make such an alternative order, there would have to be a good reason. And in this case, it's the opposite of a good reason. And the reason it's the opposite of a good reason is because of the matters that I've already brought to Your Excellency's attention, namely that it would have if an alternative order was made and Mr. Tabari wasn't a party to these proceedings, it would circumvent any ongoing freezing order that may be in place, avoid claims by his creditors, and also, crucially, would avoid a costs order being made against him personally. Because by bringing this claim in the name of an insolvent company, Mr. Tabari is shielded from any sort of costs order whatsoever.
Yes, go on.
Yes. Your Honor, at paragraph 20.
Your Honor, I don't think this argument being brought before. This is the first time my dear colleague bring this up here in this hearing.
Oh no, it's in his skeleton argument, Mr. Suwaidi.
I don't remember seeing that.
Yeah, try to see it, yes.
Yes. If I can assist Mr. Suwaidi, he'll find it at paragraph 22 of my skeleton argument. Your Honor, at paragraph 26 of my skeleton argument, I make an alternative case, and this is very much in the alternative, which is even if all the other arguments were not accepted, there are a number of rights, or alleged rights, I should say, to sort of categorize them accurately, in respect of which VIH has no connection whatsoever. And those claims include the payment of legal professional fees, registration and handover of Unit 1005 in the claimant's name, payment of 55% of the value of the unit, and anything other than the checks. And I mentioned earlier to you a company called KRT4 Limited. If Your Honour has a look at page 81 of the bundle, that's the amendment to the loan. That's the amendment. So at page 81, the first bullet point, if you see, it says an amount of 4.4, just over 4.4 million dirhams is paid to Messrs Luxury Development LLC upon the request, again, you see the language, upon the request of, it's very clear who these rights vest in, upon the request of the second party in favour of KRT4 Limited as advance payment. So this just goes to show that the absolute nonsense of this claim, that one of the claims that's being advanced is that this property be transferred to VIH, when the agreement says nothing about VIH, it says KRT4 Limited. But as I say, that's very much in the alternative, and those alternative submissions are set out at paragraph 26. I'm not going to deal with those further unless Your Honour wants me to.
Yeah, but what I'm saying, in this amended agreement, VIH is only the receivers of the checks rather than any other assets or cash money. Yeah.
Yes, that's correct. So VIH is just mentioned in relation to being receiver of the checks. So hence the point that this is no more than a payment mechanism. So what Mr. Tabari has done under both the LSA and the amendment is that he said, well, these monies are owed to me. I'm due interest under these agreements. And I want you to pay some of the money here, some of the money here. And if I later decide I want it paid somewhere else, then I can instruct you to pay it somewhere else. And so I, Mr. Tabari, am in control of this. I have the rights, which is why the claim should be brought by him. And even
you're saying they are not assignees to this right, but they are just payment channels. That's what you say, Mr. Madhani.
Indeed, Your Honour. And in fact, there's nothing to evidence an assignment of these rights. There's never been an assignment first of all, an assignment document has never been produced assigning rights from Mr. Tabari to VIH. Secondly, this agreement can't operate as an assignment because in the agreement, Mr. Tabari reserves his rights for payments to be made however he sees fit. So if he sees fit for the payments to be made to KRT, they should be made to KRT. If he sees fit for them to be made to VIH, they should be made to VIH. Under an assignment is an absolute transfer of obligation, an absolute transfer of rights. This is not an absolute transfer of rights. And as I say, even if one were to accept the claimant's argument that this is somehow some sort of hybrid, again, no legal basis for it has been put forward, some sort of hybrid where there's a joint right that both parties have, they fall foul of they fall foul of RDC 20.10.
You said no basis for it, and then you said previously it's not pleaded that way either.
It's not pleaded that way either. But what I and again I go back to my original point, which is I could have simply stopped and said it's not pleaded. That's the end of it. Because it's not pleaded, the pleadings disclose no reasonable grounds for bringing the claim. But what I've sought to demonstrate by taking it a stage further is to demonstrate to the court that even if it had been pleaded, the argument would be misconceived.
Yes, Madhani, you may move on.
Thank you. So, Your Honour, this brings me to the second ground upon which I say that the claim ought to be dismissed. And if Your Honour had said to me at the beginning of this hearing, Mr. Madhani, I'm afraid I've only got 5 minutes to listen to you today, and I'm only giving you 5 minutes, then this is the point that would have been advanced, because this is really the crucial point. The other arguments are also correct, but the crux of this falls on ground number 2.
But I can only tell you that you just got 56 minutes to go for all of your coming points.
I'm grateful.
I wish he said 5 minutes for you, Mr. Madhani, but I didn't.
No, I think the time is divided to 2 hours for each. Yeah. Am I right, Shahla? It's up till 4 o'clock. Yes. Shahla, if you still
It's scheduled until 3 p.m., Your Excellency, but we can stay till 4.
No, I mean 4 hours. Yeah.
Yes, 4 hours.
Yeah. Right. Thank you.
So,
Yes.
Your Honour, in relation to ground number 2, the key point here is that Mr. Amjad was not a party to either the loan settlement agreement, the LSA, or the amendment, and at no time agreed to guarantee the obligations of Town Square under those agreements. And this is evident from the agreements themselves. And I think it's worth actually spending a little bit of time and going to the agreements themselves. So to start off with, if I can invite Your Honour to go to page 73 of the bundle. Your Honour, this is a loan settlement agreement. It's very clear who the parties to this agreement are. And also one should remember here, Your Honour, that we are talking about sophisticated commercial parties who have advisors. Mr. Tabari is a sophisticated businessman, and I don't think anybody would dispute that, not even Mr. Tabari himself. And again, if we look at the loan services agreement, it's clear this amended agreement is made by and between Town Square Investment LLC and Khaldoon Rashid Sayed Al Tabari. So it's very clear there are only 2 parties to this agreement. And if we go to the end of that agreement, so that's page 76 of the bundle, and that's the signature page. Again, it's very clear who the parties to the agreement are. The first party, Town Square Investment LLC, and the second party, Mr. Tabari. There's a signature which is Mr. Mahdi Amjad's signature, and there's the company seal. So there's no room for doubting who the parties to this agreement were. And then if we go then to the amendment at page 80 of the bundle, it's the same point. So at the top it says, agreement made by and between Town Square Investment LLC, Khaldoon Tabari, and they're defined, the first party and the second party. Again, we go to the last page, page 82. The first party and the second party. First party, Town Square Investment LLC, second party, Mr. Tabari. Again, very clear who the parties are. So put a slightly different way, Your Honour. Neither the LSA nor the amendment was signed by Mr. Amjad as a legal person. This signature at the end of both of these agreements is not the signature of Mr. Amjad. It's the signature of Town Square Investment LLC, acting through Mr. Amjad as its authorised signatory. Mr. Amjad has never signed this agreement. It's the company that has signed this agreement. acting through him as an authorized signatory. And that is why the company seal is also in the agreement. And
Yes.
on this point, it's worth coming back to the witness statement in reply to the application put forward by the claimant, in which they said, it goes without saying, and I'm quoting from their own witness statement, it goes without saying that a contract cannot bind a third party to an obligation. They've accepted the legal proposition. And it's a fair concession because it's absolutely correct. The contract cannot bind a third party to an obligation. And that's pretty much the end of it. There's no conceivable basis upon which liability can therefore attach to Mr. Amjad. There are 2 points which the claimant has relied upon in its witness statement and reply. The first is this vague notion of context and language of the agreements suggests that it was intended that Mr. Amjad would be a party. Well, firstly, that's misconceived because it would require the court to go against the express language of the agreements, which state in terms who the parties to the agreement are. It would also go against the fact that Mr. Amjad was very careful to make sure that he didn't sign a guarantee. And also, it simply would not make sense for Mr. Amjad to give a personal guarantee in relation to these 2 agreements, where even the claimant accepts that under the original credit agreement with Investbank, Mr. Amjad did not give a personal guarantee. The second point that has been relied upon in the witness statement and reply are a number of WhatsApp messages allegedly exchanged between Mr. Tabari and Mr. Amjad long after the agreements were entered into. I'm not sure if that's a point that's realistically maintained. If it is, I've set out my arguments in relation to those in detail at paragraph 33 of my skeleton. The reason I say I'm not sure whether it's still maintained is because this point was not relied upon in Mr. Suwaidi's skeleton argument. So I'm assuming that it's been withdrawn. But if he does decide to rely upon it, I can always address it in submissions and reply. Finally, it's evident that the reason the claimant brought these proceedings against Mr. Amjad, rather than against Town Square, is to place pressure on him to extract a payment when in fact no payment is due. And in this respect, it's worth noting that this is the second occasion on which there's been an attempt to extract a payment when no payment was due. So if I can take you on to page 85 of the bundle, that is a letter.
1st of August, 2022.
I'm sorry?
1st of August, 22.
Yes, exactly. 1st of August, 2022. That's a letter sent on behalf of the claimant to Mr. Amjad. And the crucial paragraph is the 3rd paragraph. The 2nd sentence, on the 8th of July, after extensive court process, the Dubai courts finally ordered the 3 defendants, Town Square, Omniac Gulf Real Estate, as well as you, Mr. Mahdi Kazim Mohammed Jawad, to repay the client the total amount of 32 million dirhams plus interest at 12%, from the date the amount fell due until the date of full payment. In addition, the defendants were also ordered to pay the fees, expenses, and advocacy fees of 1,000 dirhams in favour of the client. Now that's false. That's completely false. There was never any such judgment that was obtained. If there was such a judgment, we wouldn't be here. The Dubai Court of Appeal on the 8th of July, in fact, dismissed Mr. Tabari's claim for want of jurisdiction and ordered Mr. Tabari to pay the costs of the proceedings. That's to say that.
Yeah, but Mr.
Yeah.
Mr. Madhani, the claimant is not relying on this letter at all, I think, in this proceeding, isn't it? They're just relying on the agreement and the amended agreement.
Indeed.
Oh, see.
The claimant is not relying upon the letter, but I'm relying on the letter. And the reason I'm relying on the letter is because in this letter, this was a letter written to my client in which it was stated.
Well, it's not a criminal proceeding. We're not talking about a pattern here, Mr. Madhani, isn't it?
Not talking about
A pattern.
a battle. No, we're not talking about battle.
Yeah.
And but the point I'm making in relation to this letter is that this letter stated to Mr. Amjad that a judgment had been obtained against him for 32 million dirhams, when in fact no judgment had been obtained against him for 32 million dirhams. In fact, the judgment said the opposite. The judgment said that the judgment was for the claim in the Dubai courts to be dismissed.
Yeah, see, your problem is that Dubai court finally ordered the 3 defendants. That's your main problem, isn't it? They have not said the court first instance even. They said the court finally ordered. That's what troubled you, Mr. Madhani, I guess.
Well, there's a lot that troubles me about that paragraph. The word finally troubles me. But
the letter itself troubles you.
The entirety of the paragraph troubles me. And again, I make no criticism of Mr. Suwaidi. That letter was presumably written by him on instructions from his client.
Tell me, when this letter was written, the Court of Appeal judgment was already out?
It was already out.
And I thought after. Is it after or before? I mean, would you remind me? I remember there is a. I mean, this is overturned by the Court of Appeal, but I can't remember the date.
So the court of well, it's interesting, Your Honour, because the Court of Appeal judgment was on the 8th of July 2020, and the judgment that's relied upon in this letter is the judgment. It actually says the judgment on the 8th of July 2020. So the right judgment has been relied upon, but what has been misrepresented is the contents of that judgment.
Oh, I see.
So they're right to say that there was a judgment on the 8th of July 2020, but what this should have said was on the 8th of July 2020, the Dubai courts dismissed the claim that was brought against you, Mr. Amjad. But that's not what it says. It says the opposite. It says, we obtained a judgment against you, now pay up.
Well, if we can give them the benefit of doubt, Mr. Madhani, maybe they have written this judgment very early morning when the court just later in the day have issued the judgment. I mean, I don't know.
Well, I don't know. There's been no explanation. There's been no explanation as to why.
Yeah, but I'm just being psychiatric. I mean, that's it.
Well, yes, yes. But
maybe they were expecting such a judgment.
Well, perhaps they were, but unfortunately for the claimant, the judgment was given on the 8th of July, and the letter is dated the 1st of August. So it's not that it's not that the claimant hadn't read the judgment. They had read the judgment and they specifically relied upon it.
I'm sure.
But in my submission, what this shows is that the claimant is perfectly happy to say that a right exists where there is no right. And then finally, the point I made in relation to this, I'm going to move on because I'm conscious that my time is running out, is that the claimant has now said that they intend to apply for a joinder of Town Square. Now, from that, one can draw a number of inferences. Well, firstly, the application for joinder hasn't been made. There's no application for joinder that's before the court. Secondly, if anything, it serves as final confirmation, if confirmation were required, that the claim has been brought against the wrong party. It's Town Square that the claim should have been brought against, if against anybody. And then finally, if this claim were dismissed or struck out, that wouldn't prejudice the claimant from bringing a claim against Town Square, because of course fresh proceedings could be issued. If I can then move on quickly to ground 3, the extinguishment of the defendant's alleged obligation. I've set this argument out at paragraph 37 of my skeleton argument. So the primary argument is that Mr. Amjad didn't have any obligations under the loan services agreement, but even if he did, which is not accepted, any such obligations would have been cancelled when the amendment was entered into. And that's for a number of reasons. Firstly, and the first reason is really the crux of it. The amendment operated as a replacement of the obligations under the LSA. And so, and again, it's worth going back to the agreement itself. So one goes to page 78 of the bundle. Sorry, that's the Arabic. If one goes to page 74 of the bundle.
Yes.
The obligations of the first party. So that sets out all of the obligations. This is the original agreement, the loan, the LSA. Sets out all, that whole section sets out all of the obligations. And then if one metaphorically keeps a finger on that page and then moves on to page...
Yeah, I mean, that page said the obligation of the first party.
Yes.
First party is nominated as to be town square.
Yes.
So that means town square obligations.
Town square's obligations, exactly. So town
So
square's
they are another obligation for someone else. For example, the obligation of the second party.
Yes, so the obligation...
And if you go on, maybe obligation of the third party. I don't know.
Well, unfortunately, there isn't a section that says the obligations of the third party, because there was no third party.
I see, but okay.
Yeah. So it says, again, it's very clear, the obligations of the first party, and then it sets out all of the obligations. And then one goes on to the next page. Again, all of the obligations are set out. So that's that whole section. And then there's a second section which says the obligations of the second party. And the second party is Mr. Tubbery. Then if we go to page 80 of the bundle, and then move on to page 81, again we go to this. We go to the equivalent section in the amendment. The obligations of the first party. The obligations of the first party to be amended to read as follows, and then it sets out obligations. So all of those obligations under that heading, under the first agreement, have been replaced in their entirety by what is set out in the second agreement, the whole of it. And that includes this alleged guarantee, because that alleged guarantee was in that first section, so in the section entitled the obligations of the first party. So this amendment, in fact, operated as a replacement of all of the obligations under the first agreement. All of the obligations have been set out. So there's even reference to the checks. It's not as though this says, it's not as though the second agreement said, well, the obligations in the previous agreement subsist, but these are changes. The whole section has been replaced.
Yes.
And then the legal arguments I'll deal with very briefly, because they've been set out in detail in my skeleton. But basically, I rely upon two provisions: Article 1088 and 1099 of the Civil Code. And in Article 1088 is probably the more helpful section, in that it says if a creditor relieves satisfaction of his debt by accepting another thing, the principal obligor and the surety shall both be discharged unless third-party rights subsist in that thing. And what's happened here is that by virtue of the amendment, the unit in One Palm project was changed. So it was changed from unit 704 to 1005, and the total amount was increased. And what Town Square did was Town Square accepted the new obligations in this agreement, in the new obligations which are in the amendment. So the
But
new
can't change qualify to be like set off or waived or settled or something?
No, so the section is clear in that if one set of obligations are accepted in place of another set of obligations, the original obligations are discharged. And that makes sense, because if the principal parties to a contract change the obligations between them, the guarantor should no longer be bound by the new obligations. So here, what's happened is the obligations in the amendment have replaced the obligations in the LSA. And the amendment does not have the guarantee. There's no alleged guarantee in that document whatsoever. It's been taken out. And
isn't some can say, or maybe Sweden can argue this, that just like this amendment is just, I would say, restructuring the payment maybe, or introducing maybe a new method, or giving maybe, I don't know, some other things. So there is no payments, so there is no settlement of the loan, which hypothetically Mr. Amjad has given guarantee to.
but whilst Mr. Swady may wish to make that argument, the difficulty he has is that the obligations that were there in the LSA have been completely replaced by the obligations in the amendment. It's not as though some of the obligations in the LSA have subsisted. There's been a complete replacement of the obligations. And that's why the crucial wording in the amendment is, and I take you back to page 81. The obligation.
I can't see what has been amended, because I can see the same number of checks and then same number of amounts to be paid to investment. I guess I don't know. Well,
so you're
maybe the first property is the assignment to KRT is a bit changed.
Yes. So your Honor again makes a very valid point. The main change in the amendment is that the property has changed. So right. The property has changed and the amount of the loan has increased slightly. So the amount payable, but the property has changed to another property. It's a different unit. And when Your Honor said that the other, the checks are still there, some of the checks are still there, that really is the point, because if you look at the wording at page 81, what it says, it's very clear. It says the obligations of the first party to be amended to read as follows. So that whole previous section is no longer there. It now says that section is being replaced by this section. That's what this says. The obligations of the first party to be amended to read as follows. So the whole section the whole section in the previous agreement, which said the obligations of the first party, that whole section has been replaced by this. And this section has no alleged guarantee wording.
Okay, how about that? So let's say the obligation of the first party is amended, and let's say Mr. Amjad as a guarantor on the previous, by way or another, like I mean, this is again hypothetically. I mean, I'm taking it case by case. Yeah. And an alternative order as well in sequence. Let's suppose you convince me that the first party's obligation, which is Times Square obligation, is changed now. The guarantor or guarantee terms in the previous agreement, let's say you by yourself, by your mouth said, that cannot qualify to be the first party's obligation.
Yeah.
So if someone could say the guarantee term can qualify to something else, but not to the first party's obligation, that means the first party obligation is the subject of the amendment. And then someone might say, well, the term of guarantee is surviving from the amendment. Can we say that?
So Your Honour, the starting point, and this is in fact the slight challenge when an agreement doesn't make sense. But
yeah, I can see the whole difficulties, but I
yes.
said, I mean, within this, I mean, let's say a foggy
Within this
situation, I'm
yes.
trying to find a path through.
Yes. So just to address it in its most logical way, the starting position is that the guarantee is not binding because Mr. Amjad has never signed it, and Your Honour is right that this section refers to the obligations of the first party. It doesn't refer to the obligations of a third party, Mr. Amjad, because Mr. Amjad was never a party. So there's nothing in the agreement. There's nothing in either the original agreement or in this agreement which says, that Mr. Amjad is the third party to the agreement and Mr. Amjad hasn't signed it. But in direct answer to Your Excellency's question, the reason I say that this section also replaces that alleged guarantee wording is because if you go back to the LSA, if you go back to page 74, that alleged guarantee wording, where do we find it? We find that alleged guarantee wording in that section that says the obligations of the first party. So the obligations of the first party, and then all of those alleged obligations are set out. And underneath that, the alleged guarantee is also set out. So that's set out as
in the event of failure, yes.
Yeah, so that's set out in the obligations of the first party. So that's because it's set out in that section. It's clearly in that section. There are only two sections to this agreement. There's
two section, two parties. That's what you mean?
Yeah. Well, it's a fairly simply drafted agreement in that there's one section which says the obligations of the first party, and there are a number of provisions under it. And then there's a second section that says the obligations of the second party, and there are a number of provisions under it. And then if we look at the amendment, what the amendment does is it replaces all of the provisions of that first section, because it says the obligations of the first party to be amended to read as follows. And it's clearly got a subtitle, first, the obligations of the first party. So all of the obligations in that section are replaced. And then it does the same thing again for the obligations of the second party. So again, it goes, if you go to the obligations of the second party, it says the obligations of the second party to be amended to read as follows. So both of those sections have been replaced in their entirety, and it's very clear in this.
Yes, Mr. Madhani, go on.
I shall move on then to deal with limitation, which is a point that can be dealt with fairly swiftly.
Yes.
I've set out Article 1092 of the Civil Code, which is the 6-month limitation period for a guarantee. Now again,
What's our article number? I mean, what's the rule number? Rule number 10?
It's Article 1092 of the Civil Code.
Yes, I see it. Yeah.
Yes. So I've extracted it at paragraph 39 of my skeleton. For the sake of completeness, I should say all of the translations of the Civil Code which have been submitted are with my skeleton.
I'm checking both, by the way. If you could see this, this is. I don't know if you can see it. This is the Arabic text as well.
This is the Arabic, yes.
I'm here. I will make sure your translation match the Civil Code too.
But I've relied upon the Whelan translation. So Article 1092 sets out a 6-month limitation. What's the rationale behind this? Well, the rationale behind the limitation period is that a guarantee is a heavy obligation. It's because it's a heavy obligation, a guarantor shouldn't have a sword of Damocles hanging over his head for an extended period of time. That's why there's a very short limitation period given for a claim under a guarantee. It's common ground that these proceedings were not brought within that period of time. Now, the argument that's been put forward.
And what's the 6-month time? What's the 6-month time from the, I don't know, the amended or the settlement agreement?
So the 6-month time would be from the date that the payment was not made.
Let's say hypothetically from the amended settlement agreement.
Yes.
When this was signed, the amended agreement.
Yes. So the amended agreement was signed in
June 2018.
28th of June 2018. Yes. So it's certainly long after that.
Yeah. So by January 2019. So.
Yes.
Yeah.
So
time lapse. Yeah.
So well out of time, whether one takes it as the date of the agreement or the date of the breach. The argument that's been put forward by the claimant is that loans and facilities with banks are considered commercial, and therefore their suretyship is a commercial act, and therefore this limitation period doesn't apply to commercial suretyship.
Even if we take the case that launched before Dubai court, before this, I mean, even with that case, where Mr. Suwaidi have, I mean, sued, what was that, 2021 or 2022? I'm not sure. The case you have taken me to previously that mentioned in the letter, the case before Dubai court.
It was 29.
2019? Page 29.
2019, sorry.
2019.
And then the appeal went to 2020. But 2019, that was the time that the case was filed. Exact date, I can give you the exact date of filing, which is actually 3rd of December 2018. And exactly that was filed, but that was in the administration office, so it was later on moved to the court.
I see, Mr. Suwaidi. Yeah.
Thank you.
Your Honor, I think I see the point that Your Honor is making. However, there are two responses to that. One is that, in fact, the claim has got to be issued in the right court. If there's a limit, so taking this to its logical conclusion, if there's a claim that I have to issue in the DIFC courts within 6 months, I have to issue that claim in the DIFC courts within 6 months. I can't issue the proceedings in England or in France, and then later when I come to the DIFC courts say, well, but I did issue proceedings.
But did the rule say sue or demand? What 1092 says?
No, 1092 in my submission means the claim must be brought within the 6-month period. But the second point the second point is perhaps the more useful
I mean,
point.
maybe Mrs. Swady could help us before, because the Arabic word says mutalaba bihi. I mean, it's I don't know. Would that qualify to bringing a claim, or just even like, let's say, or could be something else less than a claim? We'll discuss that, and I will give you. I mean, I will allow you to rebuttal it if you're not happy with Mr. Sway's interpretation.
Yes,
Mr. Madhani, yeah, in his time.
So it's never been
Argued.
It's never been argued.
Well, it's before me now. Well, you raised it before me, and I can see something. Yeah.
Yeah, but certainly the claimant has never suggested that that this 6-month period means made a demand.
What I see his argument, the second argument, because this is a commercial claim and this is time extended. But I thought even within the first one, and even if you, as you suggested, it's a civil claim, or you're relying on a civil code. But I was wondering whether even the claimant or the mutalaba was brought within the time frame that before the limitation or not. That's
So yes. So that's, I mean, the first point is, in my submission, it's claim, and there's never been, and there's never been an argument to the contrary that's been advanced by that's been advanced by the claimant. The only point that they've made is this point in relation to commercial. They say it's a commercial guarantee. Secondly, in relation to when the claim was brought before Dubai courts, the claim that was brought in Dubai courts in 2018 was a claim against Town Square, not a claim against Mr. Amjad. The claim against Mr. Amjad, the claim against Mr. Amjad was only intimated much later on, and perhaps during the break I will be able to turn up the date of it, but it was certainly after. I understand it may.
I'm sorry, but I think the case was filed against Mahdi.
Well, we can go to the we can actually go to the judgment, because the judgment has been exhibited.
Yeah,
and I can turn that up. I can turn that up later. But again, this is not an argument that's been pleaded. Addressing the argument that has been pleaded in relation to the guarantee being commercial. The point that Mr. Suwaidi relies upon is that he says, because the original credit agreement was commercial, somehow the guarantee becomes commercial. And there are two flaws in that argument. The first is that the original loan under the credit agreement was in reality a loan from Mr. Tabari to Town Square. It wasn't a loan from Investbank. Investbank was used as an intermediary to enable Mr. Tabari to charge interest on the loan, because otherwise.
Well, I thought I heard you earlier saying this is a very commercial transaction, Mr. Mithan.
No, I didn't say this was a commercial transaction.
Maybe 20 minutes ago.
So you're on earlier. You're on asked me the question as to which laws apply, and I said do the civil and commercial laws apply to this case? The UAE civil and commercial laws apply to this case?
No. Believe me, I mean, I have a good memory. I remember you saying this is between two sophisticated commercial clients, sophisticated commercial. You mentioned that. We got the recording anyway. We can go to it anytime. But I recall you saying something like that. I don't know. If you will change your position, it's up to you. But I do recall you saying something like that, Mr. Madhani.
So Your Honour, what I believe I said, and I'm very happy to be corrected, but what I believe I said was that Mr. Tabari was a sophisticated commercial party, or a sophisticated businessman, and that was in the context of this. That was in the context of this agreement has been drafted, Yes, so this is not, for example, an agreement that has been drafted between two, very unsophisticated individuals, where somebody's just sort of walked off the street and signed a contract that's been put in front of them.
So you mean professional more than commercial?
That was, I think professional is perhaps your honour's wording is perhaps better than my wording, so I'm very happy to adopt that. But
commercial when it suits him, and it's civil when it's not. Thank you.
But when we look at the term commercial,
yes,
the original credit agreement, the loan was given by Mr. Tubbery. Mr. Tubbery may be a sophisticated businessman, but he's not a bank. He's not regulated as a bank. He doesn't have a banking license. VIH is not a bank. VIH doesn't have a banking license. VIH is not regulated by the DFSA to provide loans. Mr. Tubbery is not regulated by the UAE Central Bank to provide loans on interest. And so that mechanism of InvestBank was using...
Forget about it. I mean, what's the test like? What's the test in the UAE system that when you call a transaction is a commercial transaction? I'm sure there is a way to define a certain transaction between certain parties, either civil or transaction or commercial transaction.
So
I have done this 25 years ago. I can't remember it now exactly, but you.
So I'm conscious.
You may refresh my memory.
I'm conscious. I'm conscious that I'm running out of time,
Yeah.
and so I'm happy for Mr. Suwaidi to address that and for me to reply. But the short point I make in relation to this are the 2 points of my skeleton, namely that the first agreement wasn't so the credit agreement wasn't a commercial agreement because the loan was not given, because the substance of the loan was given from Mr. Tubbery to Town Square. It wasn't the substance of one has to look at the substance of the transaction in my submission rather than the form. And the substance of the transaction was that Mr. Tubbery was giving the loan to Town Square, so it wasn't a loan from a bank. Even if Your Honour were to not accept that, by the time we get to the LSA, there are no monies outstanding to InvestBank anymore. InvestBank has come out of the picture. Now all there is the loan from the loan made from Mr. Tubbery directly to Town Square. And so this...
You said this is loan from individual to company.
Exactly. So it's going from
individual
an individual
providing the loan, providing the cash.
An individual providing the cash, an individual who's not regulated by the UAE Central Bank, providing loan on interest.
To non-regulated company again.
Yes. And in my submission, that cannot be commercial because he is not regulated to provide commercial lending. And in my submission, it would be a nonsense to somehow grant an extended limitation period to an individual who has loaned monies on interest and is not regulated to do so.
Yeah, you may deal with it maybe this toward the end of this if Mr. Suwaidi bring anything more. But I would like to urge you to go on with your security for course now because you got around 12 minutes to go.
So this may then be the fastest security for cost application that has ever been heard.
Well, bearing in mind, if you skip the test, well, but I think I guess I knew the test, but you could, and it's already in your submission. And if you take me to the reality and the conditions, I mean, yeah.
Thank you. Yes. So I appreciate that Your Honour is very familiar with the test. The sum sought for security is a fairly modest sum of just over $322,000, and it's a modest sum for a claim of this size. Your Honour will no doubt have seen claims, even for interim applications, where the costs have exceeded this.
No doubt, yeah.
So it is a fairly modest sum. There's been a breakdown provided both of future costs and of costs incurred to date in relation to that. The claimant has previously conceded that it would be willing to pay security. And just going to that very quickly, the claimant has said, and I quote, the claimant was even in its witness statement in opposition to this application, has said the claimant was initially willing to pay a sum by way of security, and that they appreciate the need for security for costs. But despite that, they now say that security shouldn't be given. The grounds for security are twofold. Firstly, that VIH is no more than a nominal claimant at best, even if one takes the claimant's case at its highest. And the reasons for that have already been outlined as to why Mr. Tubbery is a nominal claimant. Secondly, it's very clear in this case that VIH would be unable to pay the defendant's costs if ordered to do so. And the evidence of that is overwhelming. One has VIH's own management accounts dated the 31st of December 2021, which are at page 194 of the bundle. And it's worth just having a quick look at those. So those accounts actually show that VIH is balance sheet insolvent. The total assets are 266 million, or just over 266 million for the second box, and the total liabilities are 294, just over 294 million. And so the company is clearly balance sheet insolvent. If it's balance sheet insolvent, it can't pay its debts, because the company technically should be subject to an insolvency process as it stands. However, if that was all, then in my submission, this would be a strong application for security for costs. However, the position is actually worse than that, because VIH has failed to provide more recent management accounts. We've asked for them, failed to provide audited accounts, or even answer basic questions regarding its financial position. It's refused to provide a declaration of beneficial ownership. It's refused to answer questions in relation to who the connected parties are. All of that has been set out in correspondence. And it was also, these documents were also requested in the disclosure process. And I'm happy to take.
Mr. Madhani, if I may clarify something.
Yes.
You bringing this security for cost application as the alternative if your immediate judgment is not granted, and if this is to go to trial, is that right?
That's correct, yes.
But this is bit, I mean, it's a bit confusing. This is, anyway, the immediate judgment application is heavy. We call it heavy application.
Yes.
It's 1 day hearing anyway.
Yes.
Even the subject matter could be 1 day hearing, so or maximum 1.5 or 2 maximum, you know, because of the nature of this loan agreement. I mean, correct me if I'm wrong, hypothetically. Why did you bring this security for cost application independently before you pursue your heavy application? Because, I mean, you already incurred costs by now. I mean, I'm sure this is a heavy application. You are on the 1 day hearing already.
Yes. So the original, if memory.
Why you have been using this tactic only? Just try to.
Yes.
I'm trying to understand. Yeah.
So there are a number of points here. The first is that the original, in terms of the trial of this matter, the original time estimate for the trial, I believe, was 2 or 3 days. I believe it was 3 days, if memory serves me correctly, but I can check that.
No.
But the immediate judgment application is a heavy application.
And it was short approaching, isn't it, before this application is lodged?
I'm sorry, Your Honour?
When the trial date?
So there is no trial date at the moment.
Not fixed.
There's no fixed trial date.
Oh, I thought it was fixed but vacated because of this.
Yes, so that's what I mean is, at the moment, there's no trial date in the diary. And it might help if I just explain how this has come about in terms of the procedural history. So in terms of the procedural history, there were the original pleadings, and then there were amended pleadings, so an amended particulars of claim, amended defence, amended reply. There was then extensive correspondence in relation to this issue of security and whether the company was in a good financial position, was in a position to pay its debts. That correspondence was very, very extensive, and the correspondence has been exhibited in the bundle.
And you said at the beginning they said they're willing to pay the cost, but then they changed their position. Okay.
Indeed, they said they were willing to pay the cost, and then they changed their mind. As you're aware, that usually the general position on a security for cost application is that one doesn't go to the merits of the application, except where the merits are clear, and that's in the rule. And in this, and the reason the security for costs application is made in the alternative in a case like this is because the merits become relevant on a case like this because of the fact that the merits are very clear. Usually on a security for costs application, and I know that Your Honour and I have had a recent outing on this. One doesn't go into the merits because it's not supposed to become a mini trial. However, the merits in this case are very clear, and therefore it's in my submission very appropriate to bring a security for costs application in the alternative to the immediate judgment application in the event that the immediate judgment application is not successful, because the parties don't want to pay for the costs of 2 applications and 2 hearings, and that's why it's put in the alternative. The second point is that this was done because there were a number of documents that were relevant, both in relation to security for costs and in relation to the substance of the claim, which needed to be provided. Those documents were requested at various times and not given, and therefore we waited until the disclosure stage of the proceedings so that disclosure could be given, and so the documents that were produced on disclosure could be submitted on this application. And a number of those documents, I could take you to particular documents, a number of those documents both going to the security for costs application. So, for example, the changes in shareholding and ownership have been submitted on this security for costs application. And a number of the documents that go to the substance have also been submitted. And I did note that in relation to security for costs, in the skeleton argument that was put forward by Mr. Swady, he did put forward this argument about the security for costs application being made late. Now, I had a conversation with his colleague at the end of last week, and I understand that point is not being pursued. But if that point is pursued, then I'm very happy to make submissions on it.
As a matter of curiosity only, Mr. Madhani,
yes,
and let's suppose you win this immediate judgment application and you're already demanding your cost and indemnity, as long as
yes.
I've seen it.
Yes.
So who's going to pay it? Before we get into the security for cost.
Well,
that risk you're taking yourself.
Well, that's
I should put myself away from it.
Well, that's
I should deal with the rest of the risk.
Indeed.
Okay. It's like a risk management instead of
At the end of the day, it is risk management in that.
If it's not fully preventive, it should be managed, isn't it? That's what you're thinking. Well, I mean, rationally.
Well, indeed. I mean, your Honour will see that the sums that have been the sums that have been spent on the proceedings are fairly modest. one could easily have spent double that amount in costs or more if one had, for instance, made an application for specific disclosure and then made an application for security for costs and then made an application for immediate judgment. However, what the defendant has sought to do is to deal with the case in a manner that's proportionate.
Well, the only things I cannot imagine what's going to be said more in the even if this goes to hearing, what's going to be said about the loan? It's either paid or unpaid, isn't it?
Well, indeed, so far as the loans are concerned, there is a slight disagreement between the parties as to how much has been paid, but both parties agree that the bulk of the loan has been paid. We say that over 27 million dirhams has been paid. The other side, I believe, say something like 24 million has been paid.
Would this case involve any expert, a forensic expert or accountant or anything?
So the original in the original directions that were given, there was no request by either party for a forensic accountant or an expert of that sort to be appointed, because, quite frankly, in relation to the difference, it's a simple question of proving the payments. There was the parties did have permission to rely upon expert evidence, but that really related to the valuation of the property, because one of the claims that the claimant has put forward is in relation to
the Palm property, yes.
The Palm property and 50% of the value, and of course that the value needs to be put on that.
Palm 1, yes, I see that.
But
well, it's 1 o'clock, Mr. Madhani.
It's 1 o'clock, and I have run out of time.
I think you've done. I mean, the only things you did not discuss is your cost indemnity, but we might deal with this toward the end.
Yes.
Yeah, I mean, I might give you a short submission on cost after my judgment.
Okay.
So you didn't have to worry about submission and cost.
I'm very grateful.
Would that conclude your presentation for today?
May I just have a short moment?
Please.
There was a short point that was raised in Mr. Suwaidi's skeleton argument in relation to the application for immediate judgment, which was raised for the first time in his skeleton argument, which I haven't addressed. I'm happy to, again, I don't know whether that point is still pursued. If it is, I can address it in reply. If it isn't, then it doesn't need to be addressed. But it's basically his argument that the application should fail for non-compliance with RDC 24.7, sorry, 24.72, which perhaps unfortunately for him is a provision that doesn't exist. I'm happy to address that. I think he intended to refer to RDC 24.82, but the short point on that is that the application has complied, and the compliance can be found at paragraph 30 of my first witness statement. So it is compliant. But again, if he wishes to pursue that point, then I can address you in detail on it.
I think, yeah, we will deal with it in turn then. Well, thank you for your presentation. Mr. Madhani, it's time to take a short break. Mr. Suwaidi, if you didn't mind, the court would need to take a break for break.
For how long is the break? I'd love to have a break myself, but I don't know how long with that 15 minutes you want. I mean,
what I'm thinking for half an hour.
Half an hour. It's okay.
Would that be good?
Yeah, for me it's good. And in fact, my time will be much shorter than the Mr. Madhani.
I'll give you 2 hours. You can utilize it the way you want.
That's okay, because my presentation will be much less than his. Shorter.
It's up to you, but you won't give in less time than Mr. Madhani anyway.
Okay. Thank you.
Then see you in half an hour. 1:30.
Thank you. Thank you.
Thank you. Good afternoon to my team too. Shahla Mariam.
I wish we really asked for 45 minutes so we could pray and at peace, you know.
You could have asked, Mrs. Sweeney.
I know, I should have had. This is what I
Because
said.
I heard you said we need 15 and I gave you 30. So I thought I've been so generous with you. I never know you needed more.
Thank you very much. Anyhow, that's what happened. For next hearing, maybe, when we will have a hearing. Although from what I see, we are discussing the whole case.
Yeah, so yeah, more or less. But yeah, and usually we take 1 hour break, but because we need to expedite things sometimes, so the judge like shorten the break. Mrs. Soid, is this your first? It must be your first before me. I don't know if
Yes,
you have attended in the DFC, yeah?
The first time.
Oh, that's good. Good luck.
I mean, it would be really good because I appeared before you when you are in the civil court, and now we are here also appearing before you when I'm here. So it's good. Great. Okay. Your Excellency, I should start or?
Yes, you may start now.
Please. You know, my learned colleague argued that the claimant is not a party to the agreement. Yes, it's not a party to the agreement. But actually, before I say that, I would say our case is very simple case, very, very simple case. Two parties agreed, a third party will receive checks as a payment for the outstanding loan. And those checks bounced. And when that party went to court, Dubai courts, to claim for the amount of money of those checks that are due, the other party, the parties claim that Dubai court has no jurisdiction to hear the case, and the case now brought before you in order to bring justice to my client. If we do what my learned colleague wants to dismiss the case, we will be denying justice to my client, which is something should not be done by the court. You know, although it is a DIFC court, but actually the applicable law here is a UAE law because this is where the party.
Mr. Swedi, just for a correction, I mean, even Mr. Madhani said you didn't have to sue Mr. Amjad, but you could sue Times Square. He said it's not the end of the world. I mean, yeah, that is. He said you're just suing the wrong party. He said he's not denying justice has to be done too. If I'm right, Mr. Madhani, sorry.
Your Honor, I think yes. Sorry. You see, we will be denied justice because as far as I know, that this company is really insolvent. It's just a paper company. There is nothing. It has no assets that we can recover.
Oh my God! What is this case? Mr. Madhani said your company is insolvent. You said his company is insolvent too, and it's.
Again, I'm just trying to say what he said against us. You know.
What a case. He said this. He said at the beginning, this is extraordinary case you're going to hear, Your Excellency.
We are actually contemplating and adding Times Square to the proceeding, but we just need to permission from our clients, instruction from our client to do so. But the way Mr. Madhani described Mr. Al-Tabari, described the case and the circumstances of the case, that he's a fugitive criminal who's run away from the country, and that's why he is claiming the amount due to him through Vision investment. By the way, there is no case against my client. He's not my client here, but he's actually my client, that he was indicted for any criminal activity. There is some investigation, yes, but now it's all closed. So there is nothing against him officially. This is number one. But what I could see, I see that Mr. Mahdi is the one is trying to run away from his obligation in this case. He doesn't want to pay anything. That's what he's trying to put all the, blame on my client. And he is actually the one trying to run away from his obligations. And I will, come to explain that to you later on. And Mr. Mahdi is a very well-known businessman. He owns a very big company called Amjad, and this Square company is just one of the company that he owns. And he did borrow money from my client. And from the argument that Mr. Madhani presented, I did not see anything in the documentation or what he read it verbally, any contemplation to pay back this outstanding. Nothing. He did not say, well, let's Mr. Tabari comes, we will pay Mr. Tabari. He say, Vision is not a party, so should has no right to sue. Vision has checks. Simple. It's a very simple case. It has a check, and those checks bounced. And what they are saying, go after the company that issued those checks, not us. When Mr. Madhani described the two gentlemen who signed those agreements, he said we have a sophisticated businessman. They have, lawyers, so they are really they know what they're doing. Yes, they know what they're doing, but the agreement, if you look at the agreement, the way it was drafted, you can't say this is actually drafted by lawyers. I think he did not come to us to draft those agreements. The agreement is very plain and simple, written by a normal people, not as sophisticated as they look. And it's really very easy wording that it's stated over there. And UAE law, as per Article 252.
Are you suggesting this is a simple? I don't know. I mean, correct me if I'm wrong. You're saying this is a simple agreement drafted by two laymen. They are not commercially sophisticated party. That's what you're saying, Mr. Medina?
Yes.
Are you sure?
Saying. Yeah, I'm saying they are. I would say, you see, they're.
I thought you were saying exactly the opposite.
We are trying to emphasize on the wording. They are, of course, both are, sophisticated people. Mr. Mahdi is one of the pioneers, actually, and started this Amjad, which is a very big business, real estate development company. He knows what he's doing. Also, my client knows, but I'm just saying the way it was drafted. The way it was drafted, drafted in a way which is a kind of very simple wording. This is what I meant,
I see.
And in fact, they both agreed, to give Vision Investment Holding, which is also one of the companies owned by Mr. Tabari and his, family. Whether directly or indirectly, I'm not really sure about the ownerships, because it's not the subject of this issue now here. They both agreed to give the right to collect those checks and encash those checks to Vision International. And Article 252 of the UAE law allow this. I have this English and I have the Arabic one. And I disagree with my colleague when he talked about the interpretation. I'm just looking at it. So if we go to, I'm sorry, I have the Arabic and English, so I get mixed up.
Take your time.
I would read actually the Arabic wording first, and then I will do the translation.
Which section is?
We're talking about Article 252 of the Civil Law.
Civil code.
Your Honor,
Civil code, sorry.
I'm sorry to interrupt, and I don't mean to interrupt my learned friend's submissions, but Article 252 has never been pleaded and it's never been relied upon before. This is the first time it's being put in front of the court.
You know, I'm just replying to what you have said, whether it is to confers right under the description, whether it's right or the word that you use, whether it's right or just I put that in my notes. Whether it gives right or a benefits.
Do you have the article before you, Mr. Madhani?
I'm sorry, Your Honor.
252. Do you have it before you?
Let me
Civil code.
Let me just see if I can open up my copy of Whelan.
It's a single statement. It's a short one,
Yes.
fairly short one. Okay, I see.
Yes.
Yes, Mr. Suwaidi, what you would like to say?
You know, because I said he was saying that's a right or a benefit, and that's why I brought this up, because I need to just address this issue. They said لا يرتب العقد. I'm going to say that in English as well. لا يرتب العقد شيئا في ذمة الغير، لكن يجوز أن يكسبه حقا. So 252 said the contract does not impose any obligation on third party, but it may establish a right in their favor. You see, and that's the translation from LexisNexis. So I'm not saying that's the official translation, but it is the translation that's available to me. So saying that the claimant is not a party to the agreement, yes, it's not a party, but that agreement gave the claimant these rights, not only through the agreements, but also through the checks. I would say the bounce checks that was given. So through those checks, now the claimant have a direct, rights to claim through those checks, and it relies on the agreement on the issue of the guarantee that was signed by Mr. Mahdi, and I'll come to that later. Okay, sorry. And then when we're saying that Mr. Tabari has runaway fugitive, so he cannot bring a claim. Yes, he's not. He can bring it, but why would he need to do so? The law allows Vision to claim, allows Vision to use the benefits that was given to it through the agreement. So it's not something that's because Mr. Tabari cannot claim, or he has some creditor that might go run away. Sorry for the words. Run. I just came yesterday night from traveling, so I was a little bit not sleeping. So it's not, forbidding him freely filing this case. Nothing forbid him. But he chose the right that was given to him by the law, and this is what he did. When you say, Mr. Madhani, that the defendant, Mr. Mahdi, is not party to the agreement, yes, the agreement is between two parties, I'm just going to show the agreement. But we have an amendment to the agreement and some amendment again to the agreement.
Now you are on the second point, Mr.
The second point,
Suwaidi.
yes, I'm sorry. I meant the second point.
Yeah, okay, I got it.
I apologize. So if we go to the agreement, the ALSA dated 12 April 2018.
Yes.
The parties, it says the parties, Sharikat Town, I'm looking at the Arabic as well. So
Page 73, Mr. Madhani.
Town Square Investment and Khaldun Rashid Al-Tabari. Now what we have here, this, of course, now we have a loan that was given to Mr. Mahdi through his company, Sharikat Town Square, the Town Square company. And it actually, the loan was given because Mahdi is there. If the Mahdi was not there, he would not have given this money. And that's why in this agreement, it shows Mr. Mahdi, in my view, he kind signed under two capacities. One capacity as an owner and the representative of Town Square, and also he signed as Mahdi himself in his personal capacity. Because under this agreement, you know, if you notice, they're putting an obligation on a third party here. Third party here is Mahdi. So and it gave a benefit to someone and gave an obligation, or put an obligation on someone. This obligation is accepted by Mr. Mahdi himself. If this agreement is signed by the manager of the company, you know, if it was signed by the manager of the company, I would accept this argument. But it is not. It is signed by Mr. Mahdi himself. In fact, he not only initialed, he fully signed all documents. Actually, the document that says, in case of any checks bounce, Mr. Mahdi will guarantee. I'm trying to translate it. I'm reading Arabic, I'm translating it in my mind. So if the translation is not really correct, I have to go back to show you the exact translation. But I'm saying, and he saying that he is guaranteed and he is personally liable, and he undertake to pay all those checks in case they bounce. Okay, if they are not being paid by the first party. So he in fact, he just signed underneath that exact wording. That means he knows what he is doing. He knows what he is doing. He accepting, and that is why my Mr. Tabari at the time accepted this. And then they want later on, if we're gonna go to the, you know, let's see, and that's why it's actually this loan was given, because he stand behind it, Mr. Mahdi. And if you see, there is no real guarantees other than the Mr. Mahdi. Why someone will give a company that much of money without any guarantees? Why? Because he knows this guy, he trusts him, trusts Mr. Mahdi, and he said, I'll stand behind it, and he signed underneath it, and he did. And the amendment that they made, of course, when they delayed in the payment, and the amendment that they made, you know, the amendment, it says, it's just an addition and an addendum, okay, to that agreement. And they did only two things that they changed. Changing the property that was mentioned in the agreement, the earlier one, and the amount that is still outstanding. So they increased it around 400,000. Exactly, to be exact, 435,729, and just changing the property. So this is this addition, and it says ملحق تعديل. It is not a replacement. So everything in that agreement stay the same, except the thing that was touched upon by this agreement. So I do not agree with my learned colleague that this replaces that, and we have a separate agreement. So Mr. Mahdi is no longer a party to this agreement, and he is no longer obliged to be a guarantor. I'm sorry, I have too many notes.
You will take your time, Mr. Sweet.
You know, if we go to the fourth point of limitations that Mr. Madhani stated, which is, you know, under Article 1092. that a 6 months, limitation period is there, and this limitation now has elapsed, so you cannot claim. I'm sorry, but I disagree with you. I disagree for two reasons.
Well, I'm sorry, you
One,
didn't have to be sorry to disagree. You just disagree.
I am, Your Excellency, I am a very polite person. I have
Yeah,
to
you,
apologize for
yeah, you all polite, and even Mr. Mithani is super polite. But when you argue before court, that is where there is argument and counter argument. So we didn't have to be sorry about it because it's our views, and saying things. Yeah,
I
yeah,
know. I know.
thank you, thank you.
Uh,
Go on, please.
I know. You caught me there, sir. So, as a back of history a little bit, the civil law, the civil code, and by the way, many people used to rely on this article, when allowing the banks. So when the banks were suing people for amount dues, and that there is some kind of guarantor. I mean, some guarantors. Many people relied on this article, and the court cases were dismissed. Long time ago. And then I remember, they ran to Sheikh Zayed, Allah yarhamah, yani, and they said, this is really dangerous because now bank cannot really claim against those guarantors. And then what happened? An immediate amendment came to the law, said that this law should not apply, to the commercial transaction. It just only apply and only should apply only to civil transaction, not commercial transaction. In fact, it is article number 1, and it was actually amended in 1987. Just immediately, I mean, 2 years after that law comes. Just a back history, Mr. Mithani. When I said why this does not apply, because of this particular things, that this law was amended. So this is what we have. The suretyship is a purely commercial transaction. So Article 1092 does not apply. And Article and why we could say this is a commercial transaction, not a civil transaction. If we just go back to the commercial transaction code, okay, you could, of course, what we have here, we have an agreement, and we have checks. And you'd agree with me that checks is part of the commercial paper, where people could use for payment, or even they can also innovate to other parties. And Article 4 of the commercial code, commercial transactional code, says act of commerce are, and I'm quoting Article 4.
Is that attached to the system? Is it in the system? Do we have it?
No,
have you uploaded?
It's actually, it's not. It's not.
I see.
It's not. But because this issue, he raised it, so that's why I'm just trying to get things into.
No, he raised it. He raised it a while ago, Mr. Suwaidi, not just today. You could have answered this earlier.
Your Excellency, as we are not really discussion, what I'm bringing up here, I am not bringing issues of facts. I'm bringing issues of laws. Okay, and issues of laws could be argued at any time. This is as far as I know. So this is an issue, and I'm really relying on what he said here, and I think we did mention that in our submission earlier. By the way, I'm trying to log into submissions, and I had difficulty checking, able to get the thing that was submitted because I could not see. Huh? And the case bundles, what I meant. So if you allow me, Your Excellency, just I'm gonna state what the law says.
Please go ahead.
Article 4 says act of commerce are, number 1, act carried out, but I will rely on number 2, speculative activities carried out by person through not a merchant for the purpose of achieving a profit. I mean, the Arabic wording is not really mudaraba, the word used, so speculative, if we could say this. Article 5 says the following activities shall be, by virtue of their nature, be considered as an act of commerce. Number 5 of that Article 5 says all kinds of transactions related to commercial papers, irrespective of the capacity of the concerned parties therein, of all the nature of the transaction for which such a transaction are carried out. Very clear, related to commercial papers. And when we're talking about commercial paper, Mr. Mahdi signed an agreement referred to commercial paper, and we're talking about the commercial paper. And they agreed that the payment through this commercial paper. Therefore, we have a purely commercial transaction in which the limitation period will not be applied.
Mr. Wade, if you may clarify this for me. I mean, you brought this case under what cause of action? I mean, are you bringing this under the agreement or under the commercial notes, or both?
Both, actually, because the commercial notes is for the claim that was claimed by my clients, and those claims coming out actually from this transactions, from this agreement, and this and this agreements, because these notes came from the agreements, and so I'm bringing up, and that agreement shows the Mahdi's guaranteeing this amount of payment. And as I said, there's this loan is an older loan, so they settled part of it, and that this is the remaining, and they agreed, both the parties to agree to settle it through this agreement and those notes. And they issued this post-dated check,
Mr. Madhani, have you managed to get Article 5 of the commercial transaction law before you?
Yeah.
I'm sure you have a good library.
Your
electronic one.
Sorry, but I also want to add one article, which is Article 70 of the Commercial Code.
5 and 70.
70.
What does that say?
It says a surety shall be commercial if the surety has guaranteed a debt which is deemed with regard to the debtor to be a commercial unless otherwise provided by law or by agreement, or if the surety is a merchant, and has an interest in guaranteeing the debt. So as I said, this is it's a commercial transaction, guaranteeing a commercial instruments. That's why it is a commercial. The commercial code would apply.
What's the limitation time for commercial transaction, Mr. Swedi?
10 years.
10 years. And what article says that? For my reference.
By the way, I'm on that thing. I'm relying on the older law because the last 2 years we just had 100 laws get amended, and we need to go through this. But I'll find that out for you now. Actually, I'm looking. Okay, I have to go through a long law. Sorry, because I just want to see. Maybe I could write that to you later on.
Yes, why not?
Because it's just.
You might ask your assistant. He will provide it for you.
Yeah, just looking at the 5 years. It says no. It used to be 10 years. It used to be 5 years. But I'm just trying to see which article it is. Doesn't say. I'm sorry, Arab. It's the new law says 5 years, not 10 years.
Again, I don't really wish to interrupt Mr. Suwaidi, but he shouldn't be relying on provisions that he hasn't put before the court previously. There's a whole, the procedure is there for a reason. And these are matters that should have been pleaded. If they were not pleaded, at the very least, they should have been raised in relation to the skeleton argument. I can address these points in reply, but if Mr. Suwaidi's in a position now where he's talking about a limitation period where he himself can't point to the provision in front of the court, it's not satisfactory for him to then provide the document at a later stage.
No. He said he would provide it now. I mean, let's go for this. I'll give you the chance to reply to this, Mr. Mithani. Yeah, Mr. Suwaidi, move on until you have the right reference.
I see. I mean, it used to be 10 years. The new law, which is very recent, I mean, I'm just looking in the internet. It says 5 years instead of 10. But it's, from what I see, it's still irrelevant because this claim is within 5 years. It was filed within 5 years. In fact, it was filed in Dubai courts. By the way, it's worth noting. It's worth noting that the case in Dubai courts is actually went to experts. Okay, it was sent to expert, and the expert came up with the report. Saying that this, showing that this is Mr. Mahdi. I think it was indebted because he was added as a co-defendant later on. And then, but later on, it was just dismissed because of lack of jurisdiction. That's the only thing, not because. I mean, I disagree with what my colleague has said. It was just dismissed for lack of jurisdiction, not because of anything else. Now, this is with regard to the limitation. As you can see, I'm not really that much organized. With regard to the issue of security of cost, and I don't know about this issue of security of cost because I really have my personal opinion about it. Sometimes,
sorry, Mr. Suwaidi, before you moving from this, what is your interpretation to the Article 1092 of the Civil Code that Mr. Mithani brought for a limitation? We discussed this earlier. We said we would raise it before. I thought you would have a saying in this regard.
It's
because Mr. Mithani said you have to bring a claim before a court to secure your debts otherwise. But you're saying you didn't have to. It doesn't have to be claim. It could be something else, isn't it? And Mr. Mithani said the claim, if it's claim is before the DFC court, the current claim, and the current claim fall out. If this is, I mean, if the argument of Mr. Mithani did succeeded that this is a civil transaction and it's time barred by this article. So I was just wondering whether the claim before Dubai court would can be considered as a claim under the meaning of this article.
Your Excellency, the word that is used is al-mutalaba. Okay, it's a claim, So the claims could be argued whether you have to find a case for that, or you just send a request for payment. You could argue it this way, but in all cases, the case was filed before Dubai courts. In fact, it went from Court of Appeal, Court of First Instance, where it was dismissed, and then went to also again continue to Court of Appeal, which was also dismissed only for lack of jurisdiction. And that's because Vision is a DIFC entity. That's the only reason that was the case was dismissed for. And they thought they had a valid case. In fact, the court itself thought the case was really valid and appointed an expert, the court itself. But later on, the court found that this is
you mean the Court of Appeal? Court of Appeal, huh?
The Court of First Instance, not even the Court of First Instance. they found that there's no jurisdiction, and the Court of Appeal upheld that decision. And then once that happened, then they came and claim here. And I just want to see exactly, I'm just looking at when this law was issued, 50, because I said too many laws that was issued at the same times. So in fact, this 5 years limitation became into existence on 3rd of October, and it will be supposed to be inactive from the 2nd of January. So the 5 years limitation, for the 10 years limitation was amended by 5 years limitation, which I'm trying to find it out now for you exactly to give you exact things, is actually coming from the 2nd of January, way after this case was really filed. So we should have the privilege of having that 10 years limitation.
If it's commercial transaction, not civil transaction.
Yes, of course, but it is a commercial transaction. In fact, I've really said the history of changing the law is because many bank was losing cases against the guarantors because of Article 1092.
And you're saying this is a commercial transaction because it's involved checks?
Involved checks, yes.
It's involved companies?
Yes, it's involved checks. It's involved checks. It's as the law said, when a commercial law says anything related and related to three things actually. Three things. There was a bank involved, and anything related to bank is a commercial transaction. Second things, it's a kind of a speculative from Mr. Tabari in this to achieve profits because he's getting interest, high rate of interest as well. Okay. The third thing is having these commercial documents or commercial paper, which is the checks. So there are three elements to it.
Thank you. Now you would like to address cost, maybe, yeah.
The security, as I said, the security for cost is sometimes I feel it's just a tactic. It's a tactic, to allow to frustrate people not getting their rights through the court. And they will always jump, this company is not worth, does not have enough money to pay for the cost. But when they went into the contract with this guy, they did not want to the contract, but they gave it the checks. They should have checked if this company is solvent or not solvent, will be able to pay or not be able to pay. They have not done that, So now they're saying this company might not be able to pay. That's why they have to address.
Well, Mr. Swedi, I'm sure they have done that because they were the receiver of 30 million. So I'm sure they knew that Mr. Tabari and his company have enough money. So yes, at that time,
but you see,
I think
you see, if you look at the whole claim, I mean the defense that were argued by defendant here, it's just trying to stay away from paying back the money he received. He received to make money on real estate and a lot of properties that he sold. He's just trying to stay away from his obligation to pay and using this.
No. He's arguing he is a different person than the personality of the company, and he's not a party to the contract, and he's not a guarantor. And he said there is no the condition of guarantee is not there. That's what Mr. Madhani trying to say. He's not saying we're not paying, we don't want to pay. Yeah, well, you might see it as a tactic not to pay, but that's how he's arguing it.
Well, I mean, I would love that maybe we postpone the hearing for another month, and then we'll see if Mr. Mahdi paid Mr. Khaldoon Tabari his dues. And then if that's happening, if that will be done, we'll cancel.
No, Mr. Swedi, he said Mr. Mahdi is not liable for the debt. He said it's it's another personality who's supposed to pay this, not Mr. Mahdi. That's what he's saying. If you wait a month or a year, am I right, Mr. Madhani, for saying this?
Your Honour is right in that Mr. Mahdi Amjad just has no liability under any of these agreements.
I'm trying to explain to him that is your position. He said, well,
Yes.
whether you give him 1 month, 2 years, 5 years, the whole time, he will not pay it because he didn't believe he's liable for it.
He's not liable, yes.
Yeah, no, you see, I want to say something here. You know, Dubai was, now it's a little bit different, you know, but Dubai businessmen knew each other very well. You know, Khaldun Tabari was a contractor, you know, and Mahdi, they use, you know, they know each other. Contractors and developers, they know each other very well, you know, and without...
Your Honour, again, I hesitate to interrupt Mr. Suwaidi, but there's a limit to how much evidence he can actually just give. These are not points in evidence.
No, it's the relevance. We have a contract in hand, Mr. Suwaidi.
Yes,
At the end of
you
the
know,
day, I mean,
why I am drawing this conclusion of this contract is that people know in Dubai is a smaller community, you know, people know each other very well.
I would disagree with you.
No,
Dubai is a very big community.
No, it is becoming like this, but before it was.
No, what do you mean now? I mean, we would keep disagreeing when Dubai became a large community.
No, it's because
I mean, I'm sure before the loan, Mr. Suwaidi.
You know, when the law, no, you see, I mean, there are big players. They know each other very well. And you
I
know,
think you talk about the 20s and 30s and the 40s. It's not anymore. I mean,
not on that level, no, but not on that level. In that level, still people know each other. Al-Abbar knows, شو اسمه هذا, the Mark. Yeah, we don't want to go into names, but they know each other very well. And that's why...
Your Honour, again, I hesitate to interrupt, but Mr. Suwaidi keeps giving evidence.
he's giving unnecessary background.
I'm just giving you a background. I'm not giving evidence, actually. I'm just giving a background.
No,
you know,
just
background. Why
okay.
why this loan was giving? Because Khaldun Tabari knows Mahdi, knows him very well. And that's why he will not give him a 30 million, you know, and that, you know, he put it in the name of this company. I mean, why someone will give someone 30 million or 40 millions or, you know, without having a real guarantees? The real guarantees was Mahdi. The real guarantor of this transaction was Mahdi and Mahdi's wealth and Mahdi's ability to repay the money.
Okay, now it's not about Mahdi's wealth. Now it's about HIV's wealth. It's the vision wealth. Now,
Yes.
Mr. Madhani is saying, I'm defending this case.
I know.
I have a defense to this, and I believe if I won this, the company will not be able to pay our cost of this litigation. And Mr. Madhani said, there is nothing in the horizon or nothing in the pleaded case, nothing in the question sent to you, nothing in the financial data and information would say, if Mr. Mahdi won this case, your claimant would pay his cost of advocacy and the cost of this case and the fees of this case.
We have the checks. You can attach the checks. You know, the checks is in, it has how many? Around 30 million. You know, 32 million.
No, I'm saying if he won.
If he won, I know, and he had the 30
No,
million.
this is Mr. Mahdi against Vision. It's not Tabari. It's not Times Square, Mr.
I know, but the Vision had those checks. Vision suing the company of Mahdi. Those checks is issued by Mr. Mahdi's
Mr.
company.
Mithani, I think he would try to say, you go take your money from Times Square. That's what he's trying to say.
I know.
What is it?
This is what he's
I
saying.
think this is out of the normal context, Mrs. Sweeney.
You know, I'm just trying to look for something here. I'm sorry, you know. Get the bundle.
That's a bit, I mean, ironic.
You know. You see, now if you see the company, you see, as the DIFC court had the power to order security in accordance with ordinance over, and the claimant is not a resident of...
Yeah, you see, it's a legal power. It's not a tactic by lawyers. You see, Mrs. Sweeney?
Use, abuse. I feel we are actually in abuse process. I feel that we are in abuse process. because they tried to stop. They took my client's money and they did not pay him, and they want him now. Say, you have to show us that you are able to pay. I think we will be able to pay in case this court find us.
Okay, just tell me how you're going to be. How are we going to enforce against Vision?
Vision is a company that's
That's the question. That's the question is before you now. Just let's suppose Mr. Mithani win this case. Okay, Mr. Mahdi, I mean, Mr. Mithani, Mr. Mahdi win this case. Okay, and there is 200, 300,000, whatever advocacy cost. How are they going to enforce upon that?
Your Honor, I think the case is very simple, and I should not take that much of time. Should not take that much time. So the cost should be minimum, much less than what the figure here you stated. And I think the case is the court is the company is here available that has this financials. So if they have anything against it, he can go and enforce it. In addition, using those checks, which is issued by its own company, to deduct any money due to him from those checks. In fact, he's just a guarantor. It's very obvious that he's a guarantor of those money. Very, very obvious. It's very plainly stated. He signed underneath it. There is no way the court will find that Mahdi is not liable. No way.
No. Mr. Wali, does Vision has money?
They do. I think they do. They pay us. They pay our fees.
Do you like that answer, Mr. Mithani? Okay, it's for you, and that's for your time.
Your Honor, I'm very happy.
Answer. I'm sure you're.
I'm very happy for Mr. Suwaidi that his fees are being paid, but that doesn't address the test as to security.
That doesn't pay your fees.
It doesn't pay my fees.
And I think we did give you the documentation that shows it's a healthy. You interpret it's not healthy. I think what we send you, Mr. Mithani, it shows it's a healthy company.
Okay, and he will answer in his turn. Yeah, he did. Yeah.
There's so many things owned by this company, so if they fail to pay, you just go and liquidate them. And I think they have an asset, a lot of assets.
Is that documented? Is that part of the document of this case, Mr. Swedi?
Yes. You can go to Article 34 of this, of the witness statement that I submitted. It will show you. And also, we submitted the document, but he is not. Mr. Mithani is not satisfied. I mean, I don't think Mr. Mithani is a financial advisor, so he can properly decide on this. I cannot decide. I know as they are liquid, they can pay.
You're referring to what paragraph of your witness statement, Mr. Swedi, if you remind me?
34.
34. Account were provided the 10th of November.
Your Excellency, you already have there's a checks that's worth 30 million, at least.
Oh, not again, Mr. Swedi. I'm trying to see this financial document. Can you locate it for me, Mr. Mithani? The financial statement of the company, Mr. Swedi referring to?
Yes, it's the document that I took your Excellency to earlier. Let me just.
No, I thought you said you will take me to later, but we did. I don't think we have we visited.
I can have a moment. Pardon? 194.
194.
Sorry, but which document you're referring to, Mr. Madhani?
Page 194.
Page 194.
I see 266 million total assets. 294 million total of liabilities. Yeah, there is an interesting point, Mr. Mithani. I mean, I would like to address with you maybe later on your turn. I would if Mr. Swedi finishes.
Yes.
You can see it says total non-current liabilities, 285 million. It said non-current liabilities. I mean, I don't know if you have noticed this.
Yes, I can address that now. I can address that in reply. I mean,
Yeah, in your turn, Okay, Mr. Swedi?
Yeah, you see, it's non-current. That means it is long term. So it's nothing due for them, but it shows how much money the company has. 263 million already there, of assets. So you can enforce any judgment against this company in case we will be most fortunate if not having a proper judgment in our favor, our client's favor. So I feel that there is no real this request by the defendant is just to make our life difficult. That's all. I'm just looking at the figures. Okay. I think I'm done. Your Excellency.
Check all your note. If you're
Yeah,
okay.
I'm just going through. Okay. I'm just trying to refer to Article 24.8.
RDC?
Yes. It says here the applicant notice for or the evidence referred to and or served with it must, I would say number 2. Okay, identify concisely any point of law or provision in a document in which the applicant relies and or say that it is made because the applicant believes that on the evidence the respondent has no real prospect of succeeding on the claim or issue, or as the case may be, of a successful defending the claim or issue to which the application relates. So I mean, the case is very simple. Someone, we have actually demonstrated that. In fact, I feel that we already argued the case. That there is document that shows that the defendant has signed the agreement that shows he is obliged, and so there is a real prospect that this claim will succeed. So we cannot strike out this claim because there is enough evidence to show that the defendant will be held, hopefully, liable to pay the claimant. And thank you.
Thank you, Mr. Swedi. Thanks for your time. Mr. Mithani? I think there is some point you would like to recap or deal with. If you can take 5 minutes for each, you have maybe 3 or 4 points, isn't it?
Yes, thank you, Your Honor. What I intend to do is to just focus on the points that have been raised by Mr. Suwaidi. I'm not going to go through all of his points because a number of the points have just already been addressed. And those points probably don't take his argument any further in any event. Probably the most useful point that Mr. Suwaidi made in his submissions is what he said at the outset. And he made a point at the very beginning of his submissions. He said, yes, Mr. Amjad is not a party to the agreement. That was an admission. It was a reasonable admission and a fair admission. But what that means is that that's effectively the end of the case. That's ground number 2 of the immediate judgment application. Mr. Amjad is not a party to the agreement. And to quote the words again of Article 252 that Mr. Suwaidi himself relied upon, an obligation cannot be placed upon a third party. I don't really need to say anything more. That is the end of the case. However, I will address his other points. He said again at the beginning of his submissions that this would somehow be denying justice. That as Your Honour very rightly pointed out, is absolutely incorrect. If there is a claim that Mr. Tabari believes he has against Town Square, then he should bring that claim. That is a matter for him. This is not a case where justice is denied to anybody. Also, in the course of Mr. Suwaidi's submissions, he referred to the outstanding criminal and civil proceedings against Mr. Tabari. He said all the cases are closed. Unfortunately, however, for the claimant, no evidence of that has been submitted. Moreover, numerous requests have been made for that information and for those documents in correspondence which is exhibited to the application. And the only thing in reply has been silence. Those documents have also been requested by way of a formal disclosure request. Again, those documents have not been provided. However,
well, excuse me, Mr. Madhani, I mean, the
Yes.
nature rule is that everyone is innocent until the proof otherwise. And you're the one who's saying Mr. Al-Tabari is the fraudulent, is the escaped one, and then the proof should come from your side. And Mr. Suwaidi said he's free, he's not convicted of any yet, at least so far. Why should he prove otherwise? I mean, I think that's the normal rule, if you agree with me.
So Your Honour,
But if you have any evidence he's in jail, I would accept it.
Thank you, Your Honor. Thank you, Your Honor, for saying what should be said. Thank you.
So Your Honour, I'm not, just to be clear, and so there's no misunderstanding in relation to my submission. I'm not saying that Mr. Tabari is definitely guilty of that 1 billion dirham fraud. That is not something that, and again, I go back to what Your Honour's very properly said earlier during the course of my submissions. That's not something that I need to prove on this application. All I've simply said in relation to that is that there was an order from the UAE public prosecutor. There was an Interpol red notice. Neither of those points are disputed.
Yeah, but we all know prosecution doesn't decide cases. It's courts who decide cases. Anyway, yeah.
It does. But the only point in relation to that is those proceedings have been outstanding.
Believe me, I got a friend of mine who's a judge. The central bank frozen his account. They didn't know who he is, and he has to go to the attorney general, the federal attorney general. Said, "What's going on? Why my account is frozen and my money is?"
Yes.
And then they said, "Oh, well, sorry, we didn't know who you are anyway." I said, "It's not about who I am. Why you have done this?"
Yes.
To anyone, not just a judge. I mean, why anyone else would be subject of that? But I said, things happen. I mean, anyway, so the attorney general could do things even to the judge, but that the final things happen. I'm sorry to bring this, but to show you how things go sometimes.
Yes, and I hope Your Honour's friend manages to get his accounts
unfrozen. He did 3 days ago. Yes, he did.
That's reassuring. But the simple point the simple point I make in relation to this, and I don't want to dwell on this because this is really a little bit of a side point, is that those matters took place.
Sorry, I need to tell you, because he received money. He was acting as an arbitrator in a certain case,
Yes.
and the money goes to his account, and then they thought this is suspicious transaction. So, and he has to clear things out. So.
Well,
That's why he said arbitration kills. I said, how? And he brought this story. Sorry for that.
I think that's one that we might use during the next Dubai Arbitration Week.
Yeah, arbitration kills, and you can tell them why.
But I don't really make any more of that point. My point in relation to that was simply that the requests had been made and the requests had never been answered. Again, there was a point made by Mr. Suwaidi during the course of his submissions that, again, is something that was not in evidence. He said Mr. Amjad is the owner of Town Square. He is not the owner of Town Square. That is incorrect, and the submission made by Mr. Suwaidi is not supported by any evidence. He also went on to say that the agreements were not drafted by lawyers. Again, that's not in the evidence. It's not supported.
No, to be fair, he said from at the face of it. He said,
yes.
Thank you.
But in terms of who has drafted the documents, on the face of it, in my submission, the documents have been professionally drafted, and the signatory, Mr. Tabari, the signatory to that agreement, is somebody who is a sophisticated businessman, the former CEO of Drake and Skull. In relation to the Article 252 point that Mr. Suwaidi relied upon, this is the first time Article 252 of the UAE Civil Code has been mentioned. It has not been pleaded. It has not been mentioned in the skeleton argument. It has not been relied upon. It's too late in my submission for Mr. Suwaidi to rely upon it now. But even if he is allowed to rely upon it, it does not get him any further. And the reason it doesn't get him any further is because if one looks at 252, and I'm reading from the Whelan translation, it says very clearly, a contract may not impose an obligation upon a third party. That's correct. But it may vest a right in him. And Your Honour will remember from my earlier submissions that I said, even if one were to take the claimant's submissions at its highest, none of the agreements vested a right in VIH. The right was simply not vested, and I set out in detail why the right was never vested. There was no express provision in any of those agreements vesting the right in VIH. The right at all material times remained with Mr. Tabari. That's the first point. The second point is, again, going back to my earlier submission.
so no, you're saying no right vested or assigned to another party?
No right vested or assigned. There hasn't even been an allegation of an assignment of the right.
And you didn't think the wording of the contract suggests so?
No, in my submission, not, because of the reasons I've set out earlier, but including the fact that there is no wording in the contract that says that the right to bring a claim, or any alleged right to bring a claim, whether it's a claim against Town Square or against anybody else, is vested in VIH. That's simply not what the agreement says. And as
Mr. Madhani, I mean, if the right, I mean, is vested or assumed, it would happen so without the mention of to bring a claim. The contract or the wording could say, so and so have right to. It wouldn't say to have right to sue, but have right to the money, have access to the certain things. I mean, that what would happen, and then in the due course. I mean, I don't think it's a normal situation where a commercial contract or a professional contract would say, usually, certain X party would have the right to sue or to bring claim in this court before that judge to pursue such a right. Who said, you just have that kind of right, full stop, I think.
Yes.
Correct me if I'm wrong.
So Your Honour is absolutely right in that where there's an agreement between A and B, it would make no sense for the contract to say A can bring a claim against B in relation to the obligations in the contract, and B can bring a claim against A. That's absolutely correct. In my submission, where a contract purports to grant rights, not benefits. There's a difference between rights and benefits. Where a contract purports or is intended to grant a right to a third party that is not a party to the agreement, then that contract needs to say that the right is vested. So the right to bring a claim is vested in that third party. So it needs to make it expressly clear that the third party has that right. And the reason is because otherwise there is confusion as to who has the right, because the right must always remain with the contracting parties. So Mr. Tabari was the contracting party. Again, I go back to the point that it's not that there's no right. Any rights under that agreement would be with Mr. Tabari, but not with VIH. But even if I'm wrong on that, even if Your Honour does not accept that submission, we still go to the second point, and this is assuming that there is some sort of joint right that they both have, that under the relevant provision of the RDC, the claim cannot just be brought by one party. The claim cannot just be brought by VIH. Mr. Tabari has to be a party to the claim, and Mr. Tabari is not a party to the claim. And the order under the relevant provision 20.10 has never been requested or made. And if it had been requested or made, there are good reasons why it shouldn't be made.
Merci.
The other point that Mr. Suwaidi made under this first ground, he said that the claimant had a right. The claimant had a right under the checks. However, this is not a claim on the checks. There has been no claim brought in these proceedings on the checks. And if one looks at the particulars of claim, the amended particulars of claim, it's very clear that the claim is not a claim on the checks. And that is not surprising. The claim could not be a claim on the checks because Mr. Amjad is not a signatory of the checks. The claim is a claim under the agreement, and that is how it has been expressed. And there is no other way in which there's no other way in which the claim could be expressed. I then come on to Mr. Suwaidi's submissions on the second ground, that Mr. Mahdi Mr. Mahdi Amjad is not a party. And again, it's been accepted during the course of this hearing that Mr. Amjad was not a party to the agreement. There's absolutely no basis for bringing a claim against somebody who is not a party to the agreement. One cannot, and again, this has been accepted by the claimant, that an obligation cannot be imposed upon a third party. There's a short side point here, and I think Mr. Suwaidi made it as a sort of advocate's point, which was, well, why would somebody then pay all of this money to a company without a personal guarantee? In my submission, that's a bad point for a number of reasons. Probably the most obvious reason is that if one looks at the original credit agreement, even on the claimant's case, they don't say that there was a guarantee, a personal guarantee on the credit agreement. And it's clear that the reason Mr. Tabari loaned these monies to Town Square is because there was a substantial rate of interest that he was getting. So that was the reason he did it. It had nothing to do with a personal guarantee, and of course, such a personal guarantee was not given.
Yeah, but Mr. Sweeney was not. I mean, I'm not defending him, but as I recall it, he was talking about the. He wasn't talking about the purpose or the commercial purpose of the transaction, but he was saying, usually with this high value of money, no one would lend it without collateral or a guarantee. And he said, from that basis, he said it's obvious from what's is in the agreement that Amjad is guaranteeing this amount of money.
Yes.
Thank you, Your Honor. I couldn't say it better than me. Yani. Thank you very much.
Your Honor, the flaw. I understand that that's the argument put forward by Mr. Suwaidi. The flaw in that argument, though, in my submission, is that if one takes a step back and one looks at what happened before the loan settlement agreement was entered into, there was this credit agreement that was entered into between Investbank, Mr. Tabari, and Town Square. And under that agreement, there was no guarantee. There was no guarantee under that agreement either. So there was no guarantee under the credit agreement, which was the if you like, the first agreement in time. There was no, in my submission, there was no guarantee under the second agreement, because the second agreement, Mr. Amjad was not a party, just as he was not a party to the credit agreement. And there was no guarantee under the third agreement, because again, Mr. Amjad was not a party to the third agreement.
Well, this is a striking point. I mean, Mr. Mithani, you're raising it. It's a bit risky when you have just said the first credit agreement did not mention the guarantee at all, but the second one did, because there was a fault in payment. And maybe
Yes.
that was a commercial purpose. Is that right? Or maybe something led to this new change in the what called the settlement agreement.
So whether, Your Honor, whether Mr. Tabari wanted this guarantee provision in there or not, in my submission is not the point. The simple point is that Mr. Amjad never signed the guarantee. As I said at the beginning of my submissions, if one looks at the loan services agreement, and this is really the crux of the case, if one looks at the loan services agreement and the amendment, Mr. Amjad was never a party to any of those agreements. He never signed any of those agreements. The agreements were signed by the company. So the agreements were signed by Town Square, acting through Mr. Amjad. So he signed the agreements on behalf of Town Square. If there had been another, and it's very clear who the parties to the agreement are. The parties to the agreement are set out in the agreement at the beginning of the agreement and at the end of the agreement. It's very clear. And if it wasn't clear, the concession has been made by the claimant itself that Mr. Amjad was not a party to those agreements.
And so, Mr. Mithani, please wait, Mr. Wadi. I mean, Mr. Mithani, you're trying to distinguish between legal persons or legal personalities in here, between like the company and the person who's signing this contract as a representative. Okay, I would take your case at the highest. This is between Times Square and Mr. Tabari only. Mr. Amjad there because he is the legal representative. During that signing, Mr. Amjad, the legal representative of Times Square, while he is signing, have come across I do want to call it condition, let's say a term. I said, I would take your case at the highest. Have seen a term saying that in case of default, Mr. So-and-so Amjad, who's witnessing this document, seen that term, mentioning his name. In case of default, he will repay the check's amount to Vision. And you say, despite this fact, he's not signing this guarantee because the guarantee was not directed to him as a party. That's something said, and he cannot be bound because the status then was not a party or guarantee, and this is not a guarantee document. Is that what you're saying?
Indeed, Your Honor. So he signed a guarantee. A guarantee is a very particular and peculiar obligation, and it's because it's a very particular and heavy obligation that it has to be very clear. So in this case, Mr. Amjad signed. In this case, Mr. Amjad signed the loan services agreement and the amendment on behalf of the company. So he did sign it on behalf of the company. However, he did not give a personal guarantee. If there had been a separate signature, or if there'd been a separate section in the agreement that said, well, there are three parties to this agreement, and one of those parties was Mr. Amjad, and Mr. Amjad had signed it in his personal capacity as well, then he would be bound by the guarantee. But that's not what the agreement has said, and that's not what he did. He signed the agreement as a corporate, effectively as a company, as a corporate person. So the company agreed to this. He, however, did not take on the onerous and heavy obligation of being a personal guarantor because he never signed the agreement in his own name. Now, of course, it might have been open to Mr. Tabari to say, well, I want you to sign this as well. I want you to be a personal guarantor. But that's not something that's not what this case is. This case
that's another contract. That's what you.
That's another contract. So if Mr. Tabari wanted Mr. Amjad to be bound by
and that contract supposed to be in what form? Well, do we have a specific form for the guarantee contract?
Well, that guarantee. We're sort of going into the realms of speculation.
Okay, I will ask you another question. Did Mr. Amjad made any reservation about that guarantee clause in the contract?
So Mr. Amjad has not signed. The reason Mr. Amjad didn't need to make an express reservation in the agreement is because he did not sign the agreement in his personal capacity. It was the company that signed the agreement, and so he was simply never agreeing to the obligation because he couldn't agree to the obligation when he wasn't a party to the agreement. For him to have been bound by the agreement, he would have had to have signed the agreement in his personal capacity. If he had signed a subsequent agreement, which was a guarantee saying, I, Mahdi Amjad, guarantee the obligations under the loan services agreement and or under the amendment, then that would be a binding guarantee. But that's just not a document that he ever signed or that was ever entered into.
I see your point clearly, Mr. Madhani.
Thank you, Excellency.
I'll come back to you. Let him finish. Mr. Madhani, yes, please.
Yes, if I can then move on to the limitation point. I'll do my best to address this point fairly briefly, but there are a number of provisions that have now been relied upon by Mr. Suwaidi. So
yeah, 5.3 and 70.
So I do need to address them. The starting point, I say, is still Article 1092 of the Civil Code, and Mr. Suwaidi was kind enough to give us a history lesson, but the commercial transactions law didn't amend. Let's be clear, it didn't amend the civil code. It was a separate law, and the issue is whether or not the alleged guarantee in this case falls under the civil transactions law or under the commercial transactions law. And if I can just go straight.
Can I ask you both a very controversial question, if you allow me?
Yes.
So since we are talking about the guarantee, this is the exit for Mr. Suwaidi to get into this transaction. Can we say the guarantee itself is a civil transaction or it's a commercial transaction? So the guarantee would follow the main contract, or it's just separate agreement? It could be like having a different description. Mr. Madhani.
So I mean, my primary submission would be that there is no guarantee.
I'll tell you why I'm
if,
saying this, because the first minute you warned me, Your Excellency, this is a completely complicated, and you have another description. This is, you haven't seen case like this before. You warned me, so I'm living. That's kind of, this is a unique case.
Well, I said it was unique insofar as.
No, but do you agree with me? If there is any form of guarantee, the guarantee is a different contract than the commercial transaction, isn't it? You agree with me? If there is one, I'm saying, if there is one.
Yes. I'm dealing with the point on the hoof a little bit, but
by the way, it's very complicated, and even in this guarantee contract, and like the right is going for whom? I mean, you know what I mean? Guarantee whom? Guarantee what? Guarantee for whom? I mean, it's. I mean, I wish Mrs. Suwaidi had bleeded it in much better way.
Well, if it had been pleaded, it could certainly have been answered in more detail. But trying to answer your honest question. My first submission would be that
I know you're first, I know you're second. Go to third.
Yeah.
This is not a party. This is not a party.
Yes.
Go to the third.
If one assumes for the purposes of argument that there is a guarantee, the guarantee, in my submission, one can have a guarantee that is not commercial, even if the underlying obligations which it guarantees are commercial. However, in this case, I would say not only is the guarantee not commercial, but the underlying contract is also not commercial. And the reason the underlying contract is not commercial at a very simple level is because this is not, the underlying contract is not a loan from a bank to an individual, which is the line of cases. It is instead a loan from somebody who is unlicensed and unregulated to provide money lending on interest to a company. So that, if you like, is the high level point. Drilling down into the detail based upon the provisions of the commercial transactions law that Mr. Suwaidi has relied upon, I can address. So first of all, he relied upon Article 4.2 of the commercial transaction law, and I have his translation here. Acts of commerce are acts carried out by a merchant in relation with his trade. Well, this was not something that was Mr. Tabari in relation with his trade. Mr. Suwaidi, I understand, relied on the second part of Article 4, which is speculative activities carried out by a person, though not a merchant, for the purposes of achieving a profit. Now, in my submission, it cannot fall within 2 because of the simple fact that Mr. Tabari was not licensed. I mean, it's one thing for the provision to relate to speculative activities, but Mr. Tabari was not licensed or regulated to do that. And so it would be a nonsense, in my respectful submission, for the character of commerciality or legitimacy to be given to an act which is incorrect because he was not licensed. If Mr. Tabari had been licensed to provide to lend money on interest, if he had a UAE central bank license that he was waiving on this application, that might be a different point, but he doesn't. He's never been licensed. So Article 4.2 does not assist. And then similarly, in relation to Article 5, the claimant has relied upon all kinds of transactions related to commercial papers. Now, in my submission, that cannot be the reference to commercial papers can't be a reference to any contract that's entered into between 2 parties or any check that's given by one party to another, because that would mean that all transactions that ever take place between anybody are commercial transactions, and that's simply not the case. This was a civil transaction, and any attempt to give it the characteristic of commerciality, in my submission, is doomed to fail because of the fact that Mr. Tabari was not licensed. He just, and there's a reason why there are licensing laws in relation to lending money on interest. I've dealt with the foregrounds and Mr. Suwaidi's submissions on the foregrounds.
Or maybe you missed one. He said you can take your money from Times Square.
I'm
for
sorry?
the security for cost. Mr. Suwaidi said you can take your money from Times Square.
So, so I'll address the security for cost application. The biggest.
Well, I'll be back to Mr. Suwaidi. Let Mr. Madhani.
If we could deal with each issue.
I'll come back to you. Please make a note, and I'll give you a very brief chance. Huh? Okay.
So Mr. Suwaidi's comment that, well, go so far as security for costs are concerned, we'll go and ask Town Square, which perhaps was a casual comment on his part, but that really misses the point, because firstly, that's not the test on an application for security for costs. One has to always go back to the test. But if the defendant is successful, then how would he get his money from Town Square? It just doesn't make sense. And it's not the test. The test under the relevant provision is very clear, and the reasons for that provision in relation to security for costs are very clear. Namely, that a defendant should not be put in a position where if his defence is successful, he is not able to enforce an order for costs against the claimant. And it's very clear in this case, very, very clear in this case, that the company, the claimant, is balance sheet insolvent. And if one goes to page 194 of the bundle, yeah. If one goes to page 194 of the bundle, firstly, one has to remember that this is a document that's not been produced by the defendant. This is actually a document that's been produced by the claimant. They've provided this in response to a request, and the document that's been provided by them. They haven't produced any more recent accounts, even though we've asked them. If the financial position had improved, then of course they would have provided more recent accounts. But despite many, many requests, they failed to do so. But even if we assume that the financial position set out in this document is the financial position now, this document clearly shows that the company is balance sheet insolvent. It shows that the total liabilities of the company are in excess of its total assets. That is the definition of balance sheet insolvency. And what that means, if we just play it out for a moment, what that means is if the defendant was successful in its defense of the proceedings and an order for costs were made against it, and it sought to enforce this order against Vision Investments and Holdings Limited, it would rank as an unsecured creditor of a company that is balance sheet insolvent because of the fact that its liabilities are about 30 million more than its assets. What's even more worrying about this is that if one looks at the makeup of this balance sheet, there are a number of liabilities which are to there are a number of liabilities. Oh, I'm sorry, if I can just come back to it. There are a number of matters which relate to connected parties. Now, letters have been written by the defendant asking, and I'm happy to take you to that correspondence, asking about the connected parties, who are the connected parties, what amounts are owed to them. But there's never been an answer. And so what this means is that if a judgment was obtained, this company could be put into a bankruptcy process, in which case there would be less assets than liabilities. And so the defendant would simply rank as an ordinary unsecured creditor. And in fact, there may even be an obligation on the defendant to put this company into liquidation, because it's clear that it is balance sheet insolvent. They've chosen not to do so, and that's a matter for them. However, that is not a risk to which the defendant in these proceedings ought to be exposed. Moreover, we're going on the basis of the balance sheet.
But I think the paper said they have net profit of every year, like 541,000, like over 500,000.
Well, whatever they wish to say in relation to their financial position has not been evidenced by them on this application. The only evidence in relation to their financial position is this management accounts that have been provided by them and which show that the company is balance sheet insolvent. There's nothing. There's nothing, for example, that shows what their assets actually are. There's been no evidence provided of the assets. None of the requests for information have been answered. The only thing that has been produced are these very abbreviated management accounts. There have been no audited accounts produced. When more recent management accounts have been requested, they just haven't been produced. There's just been the sound of silence. And so it's clear that they would not be able to meet an order for costs if an order for costs was made against them.
Right.
The other just very short point that Mr. Suwaidi made on the security for costs application was he said the costs were very high. However, in my submission, the costs are very modest and proportionate. Moreover, it's not sufficient to just say, well, the costs are very high. There's been no criticism of any single line item of costs. There hasn't been a criticism of the rate. There hasn't been a criticism of the time, nothing. and in my submission, the actual amount is eminently reasonable. Unless there's anything else I can assist Your Excellency with, those are my submissions.
Thank you very much, Ms. Madhani. And if you allow me, I will just give Mrs. Suwaidi extraordinary chance to apply to yours. Yes, Mrs. Suwaidi, if you can go in short.
Yeah, okay. With regard to the points that I think it was rephrased in a way that I think is not correct. I did not really saying that Mahdi is not a party to the agreement. I did not say that. No, it's not mentioned his name in the beginning of the agreement. It's true. It's only Tabari and Square, Times Square, and but his name is mentioned within the agreement, and that does not preclude him from being a party to the agreement. Mr. Madhani is trying to show. I was trying to really come with the analogy from the English law background. What we here have is a transaction that's governed by UAE law, and in UAE law that will be considered. He will be considered as a party to this agreement, and he not only, as His Excellency Judge said, that his name is mentioned. He saw it. He signed underneath it very clearly, very clearly. So he knows what he's going into.
I said that.
I mean, yeah. I mean, kind of. I mean, you question the question, you ask the questions, but it meant that is what it it shows. He signed it, and he signed his name. He saw his name. He signed underneath it. What does that mean? Does that mean he's in a disagreement with this? He could have said, well, let's cross my name. And it's very clear. It's and anything that bounced. I just want to get the wording correctly. What too many people. I'm sorry. The wording. Wording says that he would be. Okay, the wording. I'm sorry. I have a limited space here, but I have too much papers.
You have paid in full. You should have a bigger space, Mr. Suwaidi.
No, we couldn't get connect. I mean, through the meeting room, we have a bigger space.
Right.
See, it said the wording very clear. In the event of any of the above mentioned checks bounced, okay, Mr. Mahdi shall be the guarantor personally responsible and undertake to pay the amount of bounced checks within 90 days of that maturity date, where the first party did not make such a payment. So if they don't pay, he has to, and he signed it, so he knows what he's entering into, And I would fully agree with Mr. Madhani. I would fully agree with you. This agreement was signed by a manager of the company. If the manager, a third party, Mr. X, Y, and Z, or Mr. Smith, sign it, he will not be able to oblige Mr. Mahdi. But now, who is signing here is someone whose name clearly mentioned in the agreement, and he signed it. So he is a party. If I said that he's not a party, I did not mean to say that.
So you're suggesting he was signing in both capacity as a representative of the company and a personal guarantor?
Yes, he's doing that. And he's doing, I mean, and now what Mr. Madhani is suggesting, well, we should put his name in top, and then he should sign twice. But that is not a requirement under UAE law. It's not a requirement. He entered to agreement, he's mentioning his name, he signed underneath his name. That means he is agreeing to it. This is with regard to he is not a party. I think he is just an party. With regard to Article 4, now when Mr. Tabari gave them the loan and asked for interest, they did not say you are not licensed to charge interest. I'm sorry, Mr. Tabari, will not take the loan from you. I'm sorry. They did not say that. They took the loan. Now when it comes to the repayment time, he said, no, you are not authorized. Although the law is very clear about this, when he said speculative activities carried out by person, between commas, though not a merchant. That means even if he is not a licensed, so he's not a merchant, he's not licensed to operate, this is considered to be a commercial activity. Very clearly. Regarding Article 252, I did really, I was looking at the documents. I did not mention the number 252, but I did refer to it in the submissions, in my witness statement, and talked about the reference to provide rights, and that would be in number 10 of my witness statements. And I said, I just brought that up because Mr. Madhani said it could give exactly the word you used, benefits, not a right. No, it gave a right. It gave a right very clearly. The wording of that Article 252. With regard, by the way, Article 92.
So that's another new article now.
No. We're talking about. I'm sorry. I'm terribly sorry. Now, because when we talked about the limitation, the previous limitation was 10 years. When we filed the case, it was 2022. So when it came into effect, which is this year, we already had that 10 years limitation. And now it was Article 95 in the old law, and the new law, it is Article 92. When you ask me about what article, I thought it's Article 92 of the Commercial Code.
I see.
Sorry for bringing this up, but because they are the one who brought this issue of limitation, and I thought maybe we need to address it. By the way, with regard to the checks, we did mention the checks in the particular of the claims. We did mention the checks, but when we are pursuing this claim against Mahdi, Mr. Mahdi, sorry, we relying on that agreement, because there in the agreement he said that he would be responsible. Your Honor, I'm done with my things, and I think this issue of course we already dealt with. There is nothing new to add. Thank you very much, and I really emphasize that we're gonna use those checks to pay, any cost.
Oh, not again, Mr. Swedi. Thank you very much. Thank you very much. I mean, I thank you both. I think that's bring us to the conclusion of this.
Apologies, Your Honor. There was just one point, two very short points of clarification, if I may have Your Honour's indulgence on that.
If you say it quickly, yes.
I will speak. I will speak quickly. Thank you, Your Honour. I understand that Mr. Suwaidi said that he would accept the submission made in relation to Mr. Amjad not being a party if Mr. Amjad was a manager. If one looks at page 267 of the bundle, that's one of the previous agreements that was entered into, and it's very clear that Mr. Amjad was manager to the board of Town Square. I don't think it really goes anywhere, particularly this point, but I just mention it because Mr. Suwaidi said that he would accept the submission if we could demonstrate that. And the second.
You mean managing partner, or what do you mean? I didn't get it. I'm to page 266.
Page 267.
267.
I cannot go into this. So if you just put it in the screen, would be kind enough, because I'm not able to access it actually. And it is.
Yeah, I'm afraid I'm working off a hard copy bundle rather than the electronic bundle, because I was having trouble too. But I always keep a hard copy.
No, the signatory here is someone called Andoreen Nam. No, what is it? I think Amjad.
Your Honor, Mr. Nunn is the witness to that agreement.
Oh, I see.
So it's signed. It's signed. It's signed by Mr. Amjad, and it is. It makes reference to the fact that he's manager to the board of Town Square. But as I say, I don't think that point really takes matters much further. But it was just because it was mentioned by Mr. Suwaidi.
Yeah,
but
I don't know what's manager to the board.
So he, yeah, as I say, Your Honor, I don't think the point really goes.
Anyway,
but it was just by way of clarification. And then the second
point.
the second
No, the last
point. The last point is Your Honor raised a question earlier in relation to when whether the claim in the Dubai court proceedings had been brought against Mr. Amjad at the beginning, and I said the proceedings had not been brought against Mr. Amjad at the outset, whereas Mr. Suwaidi seemed to think that he had brought proceedings against Mr. Amjad at the outset. Actually, if you go to page 181,
One oh one.
181.
Right. Let's see.
Does Your Honor have the page?
Yes, this is the Court of Appeal judgment.
Yes. So this is the Court of Appeal judgment, and if Your Honor goes halfway down the page, it says very clearly, on the 30th of July 2019, the representative of the plaintiff submitted an application to join a new litigant, Mr. Amjad, as defendant. So that application was not submitted until the 30th of July 2019. So when the proceedings were issued, Mr. Amjad was not a defendant to those proceedings. And in fact, the 30th of July is the point in time when the application was made. My reading of the first instance judgment is that he was not, in fact, technically joined until that first instance judgment was issued.
Okay, see, this is to answer my question. If this transaction is to be a civil one, he was not demand to pay the guarantee until the 6 month has elapsed. And does that mean maybe they have just sued him after the expert report being lodged to the court? Maybe they just amended the case.
So that is the explanation that has been given by the claimant, that after the expert report, they decided to add him as a party. But what's absolutely clear is that he was not a party to these proceedings.
From the beginning, yes.
From the beginning. At the beginning, they sued Town Square. They didn't sue Mr. Amjad.
Yeah, but I recall, Mr. Suwaidi, your main defense is this is commercial transaction anyway, and this I mean would take us nowhere. Just to save you from raising your hand.
But
he's just see.
But the issue of you see the issue regarding what the manager was signing this. What I met Mr. Madhani is if you know if another person's name, you know, someone else, Sophia, I don't know what, she signed as a manager of Times Square, and stating that she obliged Mr. Mahdi to be the guarantor, then you are very right. That you cannot force. We cannot obliged Mr. Mahdi to be a guarantor, because that is a third party putting this obligation on him. Here we're saying that he signed him personally, himself, personally, so he knows what he's signing on, and he signed just underneath his name. So that means he accepting this. I think we already did this. We overcooked.
Thank you. And Mr. Madhani said he was signed it under one capacity as a company representative only. Well, I think I have heard enough today.
Yeah,
What UAE law?
Yes.
UAE law, this will consider him that as someone who really knows what he's doing, and he signed under his name, accepting the obligation that is mentioned.
Oh, we're done. We're done, Mr. Sweeney.
Okay.
We're about to log out.
Okay.
Thank you, Mr. Madhani. I mean, I would definitely reserve for judgment. There is one thing I need to do, because I will be visiting some of this civil commercial law article being discussed today. I didn't need to create another translation problem. If you both could agree to provide me with a certain translation from, if you can agree from the Willen site, I mean, that would be fine. Mr. Suwaidi, you could speak to Mr. Madhani. If you both could agree, like to give me the translation of article of the commercial law first, let's say the commercial code, Article 4 and Article 5 and Article 70. And then if you can agree on the also articles that you provided me earlier from the civil code, if I can remember,
252.
252, 1088, 1099, I think 144 as well, and 121.
Yes. Say the numbers again, please. So civil transaction 1088.
Yeah, 252. So what? No, 121, 141,
121,
141,
142, 252,
1088,
1088,
1092,
92,
1099.
90.
I guess this is the articles that we've touched upon today. I mean, that's why I don't want to deal with any of this while each of you have a different translation in mind, because when accuracy matter. So, Mr. Madhani, if you could provide your the translation you have from your side to Mr. Suwaidi.
Yes.
And he said, I agree, this is the translation of the said article, and then you're the applicant here, and then you just pass it to me with his consent. And if we can do this in 2 working days, that would be good.
Yes.
I think it's more than enough.
Okay.
So.
Although, Your Honor, I would really, request that you also use your Arabic skills and Arabic language to learn to read the law. Will give you better understanding more than the English ones.
Well, that would be a very difficult request, Mr. Suwaidi, because the language of this court is an English language, and I have to apply my other half of mind. Okay, the English common law one. Okay, sorry, now the English civil law one. Sorry, I'm sorry. I should have 4 quarters, not 2 halves. Yes, and then Mr. Madhani and Mrs. Suwaidi also, I will allow you to have short submission on cost after I deliver my judgment on the immediate judgment application and on the security for cost. I will decide both obligations together in one time, in one day, and then for the cost of the proceed of both application, I will allow you for short submission in short time during the judgment. Is that clear?
So short submission, one after we submit that after 2 days, you mean?
No, about the cost of this hearing. There is a big cost of this hearing. I mean, Mr. Madhani is in his mind, he wants to cost an indemnity basis. But I'm sure you will disagree with that later. But I said I will allow you to give short submission in cost. You will see it anyway. I will give direction when I deliver my judgment about the immediate judgment application and about the security for cost application. Thank you very much for today.